Good morning, everyone. Welcome to our second day of joint judiciary here in Douglas. Yes, we're not there yet. Now we're up. Well, welcome. Welcome to joint judiciary for our second day of meetings. Our last meeting of the interim, and got through a lot of important stuff and have more to discuss today. And so we're glad everyone is here to participate in this discussion. Can we call the roll?
Good morning, Mr. Chairman. This is roll call for the Joint Judiciary Committee for November 7th. Senator Case, Senator Cooper, Senator Furphy, Senator Schuler, Senator Schuler, Representative Chestek, Representative Crago, Representative Haroldson, Representative Jennings,
Here.
Representative Nemec, Representative Oakley,
Here.
Representative Provenza, Representative Rodriguez-Williams,
Here.
Co-Chairman Landon,
Here.
Chairman Washut.
Present.
All are present, Mr. Chairman.
Thank you. All right, so we carried over a topic last night, and we'll jump into that. Any opening comments this morning, Mr. Co-Chairman?
Mr. Chairman, nothing except just thanks for all the hard work yesterday. I'm really excited about some of the items that we will have an opportunity to continue to work on as we get into the session, and it's been a pleasure to work with this group. So take it away, Mr. Chairman.
Very good. All right, we have a memo for us. Katie, I think you're gonna, Chris is gonna take us on the memo. Thank you.
Mr. Chairman, members of the committee, Clarissa Nord with the Legislative Service Office. I'll summarize the memo before you today regarding homeless relocation programs. And for the committee's reference, this is Appendix 6-01 in meeting materials. And this research was conducted in response to the committee's direction at the September meeting, where you all asked us to investigate how other states are addressing homelessness. And so homelessness is a complex issue. And so for this memo, we primarily focused on the practice of relocating homeless individuals. So to provide an overview of these programs, they can serve several purposes. They can reunite homeless persons with support systems or enable those who choose to relocate to areas with more affordable housing and a lower cost of living. One thing I wanted to highlight, though, is the research we conducted really revealed there are only a few states that have either considered or formally enacted measures to address this practice. And so I'll briefly review a couple of examples for you all today where there is some oversight in place, but certainly this presentation isn't an exhaustive explanation of all the programs that are available. It certainly just provides a starting point for the committee to consider. And then finally, my last caveat here, this memo also solely acts as informational, and it doesn't demonstrate LSO's support for a particular approach to address homelessness. So starting with Hawaii, this year, their legislature enacted the Return to Home pilot program, and this aims to assist those who are originally from the continental U.S. to return to their home state. And the program establishes several eligibility criteria, which ensures that participation is voluntary. There's proper legal authorization from the court if applicable. And then the individual must also lack the financial means for their own transportation. And then in 2018, the New Jersey legislature, they considered a bill. This bill did not pass, but it would have required services to be arranged for homeless persons prior to their relocation or transportation to a different jurisdiction. And this bill more so relates to the testimony the committee received in September. And the provisions in the bill emphasize the importance of a case management plan being in place, as well as arranging supportive services prior to transporting or relocating someone. And then it also proposed penalties for those who did not follow the requirements established in the bill. And then to provide an overview of municipal programs, so several large cities, including New York and San Francisco, among other cities throughout the country, provide these programs. And so New York, they have a special one-time assistance program, and then they also administer Project Reconnect, which provides one-way travel assistance. And then San Francisco, their Homeward Bound program establishes and allows homeless individuals to reconnect with their support networks. They recently expanded this program, and they report a low rate of return back to the city. And I wanted to note here, these programs are frequently part of a broader spectrum of services that are provided to individuals. These aren't the only programs that are available. And so that concludes my overview of the examples in the memo today. And they certainly provide you all some insight in terms of where these programs are located and how prevalent they may be throughout the country. But there are other programs and approaches available to address homelessness. So I encourage the committee to refer to the attached documents. They provide more detailed information about these relocation programs in general. And then they also include information about additional options for addressing homelessness in general. With that, Mr. Chairman, I'm happy to answer any questions.
Carissa, thank you. Very much appreciated the in-depth and thoroughness of your report, and the attachments are very informative. Committee, any questions for Clarissa? Seeing none, do we have anyone in the audience wishing to testify about the homelessness issue? Anyone in the audience? Anyone online?
Mr. Chairman, we have Brad Hopkins and former Representative Sweeney as well.
Let's bring in Mr. Hopkins, please.
Yes, good morning.
Good morning, Mr. Hopkins. Will you please introduce yourself to the body for the record, and then tell us what you'd like us to hear.
Yes, sir. Brad Hopkins, Executive Director of Wyoming Rescue Mission. We're based in Casper, and just appreciate the opportunity to address the committee. Just thank each of you for your tremendous service on behalf of our state. I'm mindful of my situation. We've got 140 folks under roof here that are homeless in Wyoming Rescue Mission, and I've got a few irons in the fire, as they say. So I don't know how each of you maintain your livelihoods and serve in the capacity that you're serving. So thank you. I will say we see 85% of the people here at our facilities. We do emergency shelter for the homeless and recovery programs. 85% of those folks are from Wyoming. And I invite any of the committee members to come and see what we do firsthand if you've never been to the mission. We are really a shining example. Forgive me if I sound a bit braggadocious. I'm really bragging on the state and our community here in Casper, just the amazing generosity that makes us possible. I will say government, particularly local and state, are critical partners. So thank you. I continue to be quite intrigued with the exception clause in our state constitution that allows for aid to the poor. Combined with the fact, my understanding is the only dollars the state spends on homelessness is federal pass-through dollars. So I'm on a bit of a mission this morning. It has been noted in the news a little bit. We've seen an uptick here in Casper. You know, we're one of 4 homeless shelters, so we're very prepared to serve the need from around the state. But the last 4 months, twice the number from Fremont County here, and there has been quite a bit of interest in Fremont County of starting their own homeless shelter. We were just there Wednesday and just saw firsthand, very educational for me personally to understand the dynamics and to see what a community is like that does not have a homeless shelter. Some pretty drastic needs there, and sure love the committee to figure out how to seed fund $500,000 for that group to leverage and spring things forward. But just want to remind everybody as we talk about homelessness, These are adult, largely adult sons and daughters of somebody that God deeply loves. I'm reminded of Adam from Casper here originally, got caught up in opioid addiction, ended up blowing off his leg to try to get additional prescriptions, ended up homeless at our facilities, and has recovered. And that's our big goal, is to return people to community independence. Misty, who was from Riverton originally, bounced around in the foster care system, sexually abused by trusted adults, and ended up in the correctional system. Where does a gal like that go? One of our own daughters of Wyoming, when that's the kind of family you have waiting for you when you serve your time. And so the mission was it, and she's now serving full time with at-risk youth as an agency. But thank you for the consideration. Transportation, I saw recently, and if I'm talking too long, just tell me to stop. I could certainly go all morning, because it's such a, as Carissa was noting, that this topic is so multifaceted. There's so many dynamics, but when you're looking at transportation, it can help in some situations. From reports I've seen, we've been in the midst of 8 million tourists, coming to the state in the current year. And, not all of those are independently wealthy. So, in fact, we just found a gentleman the other day under a bridge. He was from Utah. He had no idea that we were here as a shelter. So, connecting him to help. Our population is pretty industrious when it comes to travel. So our approach is really to help the folks connect with some sort of day labor and begin saving up if they need to get to somewhere else. There are some exceptions, such as elderly folks, where they're genuinely stuck and need extra help. But with that, I'm just throwing down the challenge. Help us get a small homeless shelter started in Riverton.
Thank you, Mr. Hopkins. No shortage of challenges to come before the legislature, and appreciate your testimony this morning. Anyone have any questions for Mr. Hopkins? Yeah, Representative Chestic.
Thank you, Mr. Chair. Mr. Hopkins, we heard some testimony last night from a pastor, Methodist pastor in Casper, that there have been some people relocated voluntarily or not from Montana. Have you seen those kinds of issues happening? And is that causing you any stress or overload at your facility?
Mr. Hopkins?
Yes, sir. And I'm sorry, I did not understand coming from where?
Montana.
From Montana.
Oh, Montana. I will say historically, the 15% that we serve that are out of state, Montana's are in our top 3. It's just what we've seen for years. I mean, we've been at this for 45 years here in Casper, started by a collective of churches locally. So that's not above the ordinary. I would say the only thing that is really, and we're still trying to learn what's going on, is just the uptick from Fremont County. Generally, we've been serving 12 to 14 individuals month over month. We've been in excess of 30 plus the last 4 months. And right now, just a lot of single moms and kids connected to the reservation. So I will tell you, I did run in our trip to Riverton last week, did run into 3 Crow there in town that were connected to a recovery program. So it's I know unusual for Montana though.
Thank you. Any further questions? Representative Oakley.
Thank you, Mr. Chairman, and thank you, Mr. Hopkins. I feel like I just, I'm Riverton's representative, so maybe it would be appropriate for me to say something. So I don't really have a question, I guess, but you did mention like the unique challenges of Riverton and Fremont County, and I am acutely aware of those. But interestingly enough, and I've thought of this before, where it's just put under this headline of homelessness, but the reality is in Fremont County, we don't, almost the entire group you're talking about has a home. Interview them, they have a home. They don't want to go there because there's not alcohol sold on the reservation. And like for, at home, if like their family won't allow it or whatnot, and so they congregate in City Park. And they will tell you this themselves. I mean, you can visit with them. But so, and then when we have had things where there's places to go, usually then there are rules that you can't go there when you're highly intoxicated, because of course that causes a whole nother set of problems as far as violence and the place being a mess. And then those end up being short-lived. Because I mean, just doing a sober living in Riverton, nobody wants to go there. So it's an ongoing problem. It's a difficult problem. But I'll just from my rather lengthy experience with this stuff, just putting it under the heading of, homeless and poverty and that doesn't actually catch the problem. So, I mean, it is something that we've, as a community, have talked about and looked at addressing over and over and have done different things and will continue to do so. And I certainly appreciate your, anything that people want to do to be kind and caring and weigh in. But as you said, it certainly is a unique challenge that we have.
Thank you, Representative Oakley. It's certainly a multifaceted concern across the state, and I think that's evident. Mr. Co-Chairman.
Thank you, Mr. Co-Chairman. Mr. Hopkins, thank you for taking time this morning and appreciate all you do there. Have enjoyed the opportunity to tour the facility and visit with you in the past. I guess I would be interested in your projections. It feels like over the last 3 or 4 years that numbers have increased exponentially, not just in the shelter, but certainly in our community. So can you look into the crystal ball a little bit? What concerns you and what are you seeing? What do you hear from your colleagues in other states? Do we have something coming that we'd better prepare for? What do you think?
Mr. Hopkins.
Yes, Senator Landon, thank you. It's a little bit hard to forecast. We're certainly on the front lines and we feel a bit like the canary in the mine. I was just talking to a neighbor lady that's a bail bonds person, and she's noticing a number of things as well. I would say generally there is tremendous downward pressure right now economically on the poor. When you look at the census data, 10% of our state's population qualifies as impoverished, which that threshold 21,000 annually for a family of 3, in my mind 40,000, it's tough to make it. But so it's extreme poverty. Just simple math, 10% of our nearly 600,000 population. So a lot of factors, as was mentioned, addiction. 30 to 40% of our folks that we see are homeless directly due to addiction. This is an astronomical problem. This is why I'm not a fan in legalizing any more drugs in addition to alcohol. We currently don't have our act together when it comes to alcohol, and really no honest conversation about the catastrophic damage. When you look at Casper, 75% of our arrests have something to do with alcohol. So now we want to add additional drugs to try to make things better is foolhardy. We just see front lines, the devastation. Law enforcement's a great tool for a wake-up call for folks to turn around their lives, but I don't see things getting better, Senator Landon. I think, as I mentioned, a shelter in Riverton, not a cure-all, it's a step. There are some folks that are bound and determined with their lifestyle choices. Would not aspire at all that this would be a silver magic bullet, but it's a lot of issues with our economy and our dollars going less far right now.
Thank you for that.
Any further questions, Mr. Hopkins? Sir, thank you so much for taking your time this morning and being with us. And I too have been to your facility. It's very impressive. Just one little question. You mentioned contacting someone under a bridge, and I'm wondering, does your mission go out and try and encounter people who might be under bridges and camping in other places? Do you actually have an outreach?
We sure do. And we're going out monthly and partnering with area churches to do this, working to get it going weekly currently, but that's service that we provide to the community, and just regularly circulating around, when we see different folks that appear to be struggling, panhandling, that type of thing, seeing if we can get them to come in and take advantage of the opportunities.
Very good. Thank you so much for all you do.
Thank you.
And Representative Sweeney, want to bring Representative Sweeney, former Representative Sweeney in? Good morning, Representative Sweeney. How are you today?
Good. Good morning, Mr. Chairman and committee. Pat Sweeney from Casper. So appreciate the topic. It is of concern. We're not ready to throw the towel in. And it is, as Clarissa mentioned, very complex, not only in Casper, in Wyoming, but across the country. So what I'd like to mention, which I think crosses into Joint Judiciary's wheelhouse, is some of the issues with mental health. I have been a long advocate for the rescue mission, but recently got involved with the land trust issue, and we're currently trying to work on that here in Casper in regards to the homelessness issue around the state. Transitional housing is a big deal, and that's one of the things we're trying to work on through the land trust, and long-term recovery and all of that combined. And of course, veteran housing is another total issue in our state. As Brad mentioned, transportation to and from, not just shipping people out and after they've received help. And so all of these things, it boils down to resources. And quite frankly, Brad was being very kind. I don't believe he gets a dime from the state of Wyoming, and what pass-through money, my understanding from the federal government, is got so many strings attached with that I don't know if he's actually taking it. And to that regard, the last number I heard was like $30,000. That doesn't even touch part of the food bill alone for the facility, with feeding 3 meals a day to that many folks on a basis. The help that he has gotten some low interest loans to build the new mission, the transitional housing through WCDA, but that was on a repayment program. And recently through the Federal Reserve had a program that Jonah Bank and a number of Wyoming banks partnered with for the discipleship area that they graduate to if they so choose, which is a wonderful program. So I'm less worried about where folks are getting bussed in from. And I think you as the legislature should look at these issues long term, and how do we move towards, we're never going to solve the whole problem, but my belief is there was a group, and Brad could have spoke to this a little clearer, but from Riverton, and I believe it was led by the Northern Arapaho, and on trying to help with the situation. But I think a collaboration would be great. That's what we're working on here in Casper, is trying to collaborate with our churches and other nonprofits, trying to deal with the housing issue when it comes to homelessness. And it takes money. And so the ask this morning, I think you heard from Brad and from Dan O'Dowell. And I apologize, our city attorney, Eric Nelson, was going to he was able to join yesterday, but unfortunately that didn't work out time-wise and could not join us this morning, but from the city of Casper. But we're committed to continue to work on it. On the mental health issue, I hope that you'll see fit to support the budget requests, the appropriations in the Department of Health. We would like to see something included in there also for homeless, and as the Constitution states, the poor, which Wyoming's not doing that great a job at. So with that, thank you, and hope you'll continue to work on the problem through Judiciary.
Thank you very much. Any questions? Senator Case.
Thank you very much, Mr. Chairman. And Mr. Sweeney, I didn't quite understand what you said was what was being led by the Northern Arapaho. Can you help me with that?
Representative.
Thank you, Mr. Chairman. Thank you, Senator Case. So I believe they contacted Northern Arapaho, contacted Brad Hopkins to come over and ask his opinion on trying to help to get something set up in the Riverton area. I think their goal is to try to find a way to do something on the reservation and near their clinic, I think, is the way I understood it from Brad. That may help on the reservation, but I don't know if it would be better to have it in Riverton or Lander or where. But obviously, with your background on joint tribal, that would be totally up to the folks there. But at least the
If I ever get the chance, we follow up.
Thank you, Mr. Sweeney. I really appreciate it. There's a lot of different efforts going on, and some frankly aren't that good. And some are patently illegal, like the transportation. So I appreciate sorting that out for me, because I'm still trying to get to the bottom of how individuals were transported to Casper from Riverton, because nobody fesses up to that. I've got a few leads, but thank you very much, Mr. Sweeney. I look forward to working with these folks. Thank you.
Other questions? Seeing none, thank you. Pat, appreciate you being with us this morning.
Thank you, Mr. Chairman.
Anyone else on Zoom?
Just real quick.
Mr. Chairman, Brad Hopkins has also raised his hand. I believe he testified.
He's back on?
Yes.
All right. Get one more bite of the apple. Brad, are you there? Perhaps that was an error.
Be joining
Right.
in just a
Mr.
moment,
Co-Chairman.
Mr. Chairman.
Well, Mr. Chairman, thank you. And I think to put a punctuation mark on this at some point, we have some work left to do today, but committee, I think all of us get a sense of why we wanted to at least bring this topic up during this interim. I think Mr. Sweeney's right. I think this is a long-term thing. I honestly, Mr. Chairman, believe if we don't pay attention to this, then we've got our heads in the sand. Every other state is receiving populations that need a desperate amount of help. And if we think we're not going to get them here in our state, I think we're just not facing reality. For a long time, living in the eastern part of the state, I've been very concerned about the lack of mental health capacity on the eastern slope. We frankly don't have enough facilities that take care of the mental health, substance abuse problems that we have in our state. And as Mr. Hopkins said, 40 to 50% of the people he sees in the homeless shelter are a result of that abuse of alcohol and drugs. So I don't know that there's a silver bullet ever on this. Certainly not this morning that I'm aware of, but I think just the fact that our joint committee can begin to develop as much awareness as we can on this and educate ourselves, because it's coming. Everything I read says that that we face a potential avalanche of populations that frankly need every bit of help that we can give them, whether it's transitional or mental health facilities, either one. We could go on down the list, but we've got to move on this morning. Clarissa, thanks for all your work on this. I think it was very helpful. It's helpful to know that other states they're grappling with this too. And I think we'll read about that more and more. So thank you, Mr. Chairman.
Very good. All right, let's move on to judicial branch updates.
Wait, didn't we have that gentleman?
Is Mr. Hopkins back?
Mr. Chairman, we did have him, but it looks like he left the meeting, unfortunately.
Thank you. Ms. Butler? Welcome back to Joint Judiciary. It's always nice to have you join us.
Thank you, Mr. Chairman, members of the committee. My name is Elisa Butler. I'm the State Court Administrator for the Wyoming Judicial Branch. I don't have much of an update to provide you with today, but I did want to make a few introductions of folks we have in the audience with you today, just listening in. So we have Judge Scott Peasley from the 8th Judicial District. He primarily covers Converse County, but also Platte and Niobrara counties. Judge Catherine Rogers from the 1st Judicial District in Laramie County is here. Both of those are district court judges, so they are our general jurisdiction court judges. From the circuit courts, we have Judge Brian Christensen, who is from the 7th Judicial District in Natrona County, and Judge Clark Allen, who is from the 8th Judicial District, primarily covering Converse County, but also covers Platte and Niobrara counties as well. And then behind me to my right, you will see a number of our esteemed clerks of district court who are visiting today and may provide some testimony, I don't know, later, but just wanted to make a few introductions. Primarily, committee, what our branch does is we hear cases that come before us. So that is the primary update I have for you today. Our judges and clerks are doing the good work of hearing cases and resolving the cases that come before them. We have a few additional initiatives that we've been working on, and we've provided updates to you at various times, but I'll give you a quick rundown of some of the things that we've been working on and continue to work on. The first is the Court Navigator program, and I think we talked to you about this at our last meeting. This is a program that is designed to help self-represented litigants navigate the court system effectively. And so it basically is looking at a person in the courthouses that people can come and talk to and say, what form do I need to fill out? When do I need to be at court? How do I act in court? How do I address the judge? This eases the burden on clerks who generally have to provide that service. It also eases the burden on judges and judges' chambers because they spend a lot of time counseling self-represented litigants when they come into court. And it helps the litigants themselves, increases access to justice. So that Court Navigator program will be piloted in Natrona County. We'll cover a few different case types in Natrona County to begin with, and is slated to begin in probably February or March of 2024 is when we're looking at launching that. We're currently working with the Casper College Paralegal Program to see if we can partner and provide some court navigators and some educational credit for those in that program. So that is a work in progress and something that we'll be looking at piloting here shortly. The second program, I think, kind of relates to the topic that you just previously mentioned, and that is our diversion pilot. And so, again, we've talked about this a number of times, and you had Ben Birmingham with you at your last meeting to give you a more in-depth update on that. But that program, in a nutshell, is designed to provide low-level criminal offenders with a diversion path instead of entering the criminal justice system. And so that pilot program is slated to begin in January of 2024, and it will pilot in Campbell County with the hope of expanding if we find that it's effective in that county. So the goal of that really is to stop the recycling of people through the court system, many with serious mental health issues. And so the people who would be qualified to participate in that diversion program have to have a serious mental health issue. And again, they would be low-level misdemeanor offenders. So we're looking forward to that program. The other thing that we've been working on pretty extensively is treatment courts. As you know, during the last session, legislation was passed to transition treatment courts from the Department of Health to the judicial branch. And so we've been partnering with the Department of Health to come up with a transition plan. We are in the thick of it right now. That transition will take place in July of 2024. And so we are meeting with the Department of Health regularly on all of the administrative things that we need to be working through. We have also contracted with a vendor or contractor who is helping us work through some of the issues that we know we need to work through to make sure that it's effective and the transition goes well for those treatment courts. And then the last thing is some court automation projects that we've been working on. So over the years, we've had many conversations about case management systems with the Joint Judiciary Committee. Many of you are newer to this committee, and so maybe have not had those conversations, but the backbone of the court record for the clerks and for the courts is the case management system. That is where we house the court record. That is where the clerks do all of the accounting. For the last, we started in 2016, so 7 years, we have been working to update the case management system in the trial courts in the state. And I am happy to say that we just did that. We finished our rollout of the case management system in the district courts in October. And so that project is complete. in the implementation phase. And now our team is working with the clerks to make the system better and also to maintain it over time. And then e-filing is the other big topic that we talk to you about pretty regularly. We are moving forward with e-filing. We have a number of courts that are live on e-filing now in the district courts. And we are slated to finish that rollout of e-filing in the district courts by the end of next year. So that is moving as well. Right now, we are in contract negotiations with the vendor for e-filing in the circuit courts. And so anticipate that we will have those contracts wrapped up by the end of this year, and we'll begin piloting e-filing in the circuit courts, hopefully in early 2025. So, Mr. Chairman, that is just a quick update on what we've been working on in the court system, and I'd be happy to answer any questions if there are any.
Very good. What do you do with all your spare time? A lot of issues, a lot of ongoing things, taking quite a while to move through the e-filing and case management. And I don't know that all of us appreciate all the complexities that go into bringing those things online. So questions, Mr. Co-Chairman.
Thank you, Mr. Co-Chairman. So, Ms. Bussler, thank you for being here the last couple of days. I just wanted to touch base with regard to budget. As we go into the budget session, are we all set with many of the bullet items that you provided for us this morning, particularly the pilot program up in Gillette? I think the Joint Committee is very supportive of what we're trying to do there and supportive of the Chief Justice. Do we have the budget in place? What does the budget look like going forward? Is there something that you're hoping for support along the way? Can you catch us up on that? Ms. Butler?
Mr. Chairman, Mr. Co-Chairman. Yes, I can. Let me start with the diversion pilot, that specific question and the budget. So we don't have a budget for that diversion pilot program. We've been working pretty heavily with the Department of Health and partnered with the folks up in Campbell County just to make sure all stakeholders are on board. The plan for the pilot program is to leverage what we're doing with treatment courts in Campbell County and use that treatment court program to assist with the diversion program, at least in the pilot phase. What I think we hope to do in the future is prove up the concept. And that's the goal of the pilot program, is basically to ensure that it's an effective program. And then once we're able to do that, potentially come back and ask for funding to expand that program statewide if we need it. We've also looked into a number of grants. And so one of the things that we're looking at right now is the State Justice Institute provides various grants to state courts throughout the nation. And so we have applied for a grant through the State Justice Institute for the diversion program. It's a fairly small grant, but it will help us get some additional expertise, make sure that the program is effective and that the way we're building it makes sense and can be expanded statewide. So specific to the diversion program, there's nothing that we're asking for in the budget for this upcoming session. We do have a number of budget asks, and one of the things that we've talked to you all about is primarily positions for the administrative office of the courts. And so I gave you a rundown of those positions at our last meeting, and I'd be happy to talk about them again or answer any questions that you may have. But we do have a number of other asks. One, the other position request that we will be looking at during the budget session is additional circuit court clerk positions. So the way that we determine whether or not we need additional positions is we have what we call the workload study. And I think many of you are aware of the workload study. We use it for judges and we use it for circuit court clerks. Basically, it looks at how much work each clerk and judge in the state has and then determines if there's a need in a location. We just wrapped up, we just redid our workload study and so got a report in July from the vendor that we hired, which was the National Center for State Courts. And what that workload study indicated to us is that we're short a number of clerks in the circuit courts. So we'll be asking for 9 new circuit court clerk positions in our upcoming budget. The other really fairly big ask that we are making of the legislature has to do with employee compensation. And I'm sure you all are tired of hearing about employee compensation, but it is an ongoing topic. And just to give you some background, we in the judicial branch have never had a classification and compensation structure. So I'm sure you all have heard about the class and comp structure, the Hay methodology that the executive branch uses. In the judicial branch, we historically have never had that. And so when employee compensation, when raises came around for state employees, what basically would happen is we do a little bit of math and say, okay, what's the average percentage of compensation that the executive branch is going to get? And let's try to make it somewhat equal with the judicial branch. But what we never did is we never looked at what was market pay for our employees. We never classified them. And so recently what we've done is over the last 2 years, we've worked to create a classification and compensation structure for judicial branch employees. And what we've learned is, despite some of the work that we did to try to make it equal with the judicial branch, between the judicial branch and the executive branch, is that we are behind the executive branch in terms of compensation for judicial branch employees. So right now, the executive branch employees are sitting at about 94% of market average. That's not every employee, but if you average them all out, they're at 94% of market. Our employees on the judicial branch side are at 84% of market. So we're 10% behind what executive branch employees are paid. And so that will be another budget request during this upcoming budget session, is to bring judicial branch employee pay equal to that of the executive branch. So those are some of our asks during this upcoming budget session. And Mr. Chairman, I'd be happy to answer any additional questions that you may have.
Mr. Co-Chairman, just a quick follow-up. Ms. Butler, can you share with us if you have met with the chief executive of the state and what the reaction was? Just interested in whether or not you've had any preliminary meetings with our appropriations colleagues, or can you share with us what the reaction is,
Ms. Butler,
to all the things that you listed?
Mr. Chairman, Mr. Co-Chairman, we did talk about employee compensation at the last Joint Appropriations Committee meeting. So that was at the end of October. And so I did let the committee know that we were going to be making that employee compensation ask. We have had some conversations with the chairs of the Joint Appropriations Committee on some of the asks that we'll be making during this upcoming session. We just submitted our budget books. So that is probably being vetted right now. I know the Chief Justice has spoken with the governor about some of the asks that we're going to be making during the upcoming session. So yes, Mr. Chairman, Mr. Co-Chairman, we are having those conversations.
other questions? Senator Schuler.
Thank you, Mr. Chairman. My question is, again, along the lines of retention. Do you see the issues that some of the other departments and agencies have with retaining folks in the judiciary? And if not, if you do have those issues, what do you think? What do you believe that is the reason for that? Is it caught? Is it, you go ahead.
Ms. Butler.
Mr. Chairman, Senator Schuler, certainly we do have turnover. I would say in some locations it's more prevalent than in others, just like anything else. Obviously, not to the same scale as executive branch, just because we don't have nearly as many employees. We've seen a couple of different reasons. Pay is definitely a factor. I can't tell you it's the only factor, but it is a factor. We have had employees when we do exit interviews who will say, I would love to stay, but I'm going to get paid much more doing this other job. And sometimes it's with another state agency. And so, that's a factor. One of the things that we're also working on in the administrative office is working and looking toward employee engagement and employee wellness. We want to keep our employees. We want to keep them happy. Turnover is expensive. And if we can avoid it, that's something we want to work toward. So.
Further questions? Okay, well, thank you very much. We do appreciate you hanging in there throughout all of yesterday and today, and might want to stay around in case somebody else brings up another topic.
Thank you, Mr. Chairman.
Anyone else in the room wishing to talk about judicial branch updates? Very good. Thank you. That takes us to. I think that takes us now to anybody online for judicial update. 24 LSO 0062 working draft 0.6. Mr. Fuller.
Yep, Mr. Chairman, members of the committee, and this is 12-01 in the meeting materials. This is a bill draft that the committee considered in September. It creates the offense of intimidating judges and specifies a felony penalty for this offense. The original draft language that the committee considered was closely related to the current offense of intimidating jurors, witnesses, and officers. And after discussion that included a discussion of potential changes, the committee considered consideration to this meeting. So to run through the draft quickly, Mr. Chairman, page 2 are definitions of family member and a definition of judge. Family member is currently a parent, spouse, sibling, or child. Judge is a Supreme Court justice, district judge, circuit judge, and chancery court judge. The staff comment, which is a carryover from the September meeting, really is just the scope of the definitions of family member, what that should look like, as well as the definition of judge. And for that, the consideration would be really whether that should include district court commissioners and circuit court magistrates. Then page 3, line 4 is the substantive offense. It is a felony punishable by 10 years, a $5,000 fine, or both, if by force, threats, or another action, the person attempts to intimidate, harass, or retaliate against a judge or a family member of the judge because of the judge's role in the legal system or the discharge of the judge's duties. And with that, Mr. Chairman, a couple of notes, some of which are mentioned in the staff comment. This reflects some of the discussion, but not necessarily all of it. The one point that was discussed that I'm not sure was completely resolved was the question of whether the draft should be expanded beyond judges. There was discussion of including clerks, county attorneys and prosecuting attorneys, and public defenders as covered under this offense. The other items for consideration, first on line 7, the term another action, and what that exactly means, and whether that should be clarified or whether it is too broad in terms of what that means for committing this offense. The next question would be on line 8 and the term harass and whether that should be defined. It is defined for purposes of our stalking statute, and that definition is included in the staff comment on the top of page 4. In other places, though, the term harass, for example, in our game and fish statutes, is not defined and is just left to a plain language. And then the other question that's mentioned in the staff comment, Mr. Chairman, is the penalty. The penalty is currently identical to that for intimidating jurors, officers, and witnesses. That certainly would be a question up for the committee to decide. The other point, Mr. Chairman, and this is moving on to the staff comment on page 4, is whether the language on page 3 should be limited to an attempt crime. So right now it reads the person attempts to intimidate, harass, or retaliate. That language does mirror the offense of intimidating or influencing jurors and officers. There is an alternate version beginning on page 4, line 26, that would take attempt out of it. It would just be the person intimidates, harasses, or retaliates against a judge. And then the last part of that staff comment just is the general attempt crime statute for the committee's reference. With that, Mr. Chairman, I'd stand for questions.
Very good. Thank you. Any questions for Mr. Fuller? I have, Senator, Mr. Co-Chairman.
Well, my apologies, Mr. Co-Chairman, but thank you. I've been pondering the language Mr. Fuller provided by you with respect to family. And, I never like to go south of the border and think that they're up to anything good, but the language that they used is intriguing to me because there are so many blended families out there. I noticed that one state singled out a stepchild, for example. many families many blended families don't distinguish. I mean, their child is their child. And so we may want to consider that. I don't know if you have any further comments on that, Mr. Fuller. I'm sure it's all over the map what other states do. But
Yep.
Mr. Fuller.
Yep, Mr. Chairman, Chairman Landon, I think that's squarely a question for the committee to discuss. Really, it's a question of the scope of the offense, you know, who is covered under this offense.
Representative Provenza.
Thank you, Mr. Chairman. Mr. Fuller, where else in our statutes do we have enhanced penalties based on identity of victims?
Mr. Fuller.
Yeah, Mr. Chairman, Representative Provenza, I certainly don't have an exhaustive list. I mean, the one immediate example that comes to mind would just be intimidating jurors, witnesses, and officers. Most weeks, that's what this is based on.
Anyone else? Thank you. Anyone in the room wishing to comment on this bill draft? Ms. Butler? Welcome back.
Mr. Chairman, members of the committee, Elisa Butler, State Court Administrator for the Wyoming Judicial Branch. Mr. Chairman, I don't know that we have much to say aside from the fact that we're very supportive of this bill. Obviously, we want to protect our judges. They are the ones who are supposed to be neutral parties, and we are trying to protect them for making the decisions that they need to make every day. So with that, Mr. Chairman, I'd be happy to answer any questions.
Questions from Ms. Butler? Representative Oakley.
Thank you, Mr. Chairman. I think I know the reception that this is going to get, but in trying to keep this narrow, what would your thoughts be on completely eliminating the family member, that this just relates to the judicial officer?
Ms. Butler.
Mr. Chairman, Representative Oakley, I think we would be opposed to that. And the reason is it's an easy way to get to a judge. And really the idea behind the bill is to provide a mechanism to ensure that the judges are protected and that they can make decisions without fear of reprisal. And one of the easiest ways to retaliate against somebody making a decision is to go after a loved one. So to me, it makes a lot of sense to include family members in that protection.
Representative Jennings.
Thank you, Mr. Chairman. Ms. Butler, in the last 6 months, my family has received at least 4 threats in letters and verbal. Do you think that maybe we should include other classes of people in the same type of thing?
Ms. Butler.
Mr. Chairman, Representative Jennings, I mean, I think that would be a policy decision for you all to make. Again, I think the idea behind protecting judges is to ensure that they can go into the courtroom every day and make decisions that they have to make. They don't have a choice. So the judges have to decide what is presented to them. That's required of them to do their job. They're not there to make policy. They are not there to determine the politics of any issue that comes before them. They are there to decide the issues that are presented to them, and they don't get a choice as to what those issues may be. And so I think it's a little bit different, but in reality, the decision and the policy behind whether or not you think it's a good decision to include elected officials in this is obviously with this body.
Anyone else? Representative Rodriguez-Williams.
Thank you, Mr. Chairman. Ms. Butler, on page 3, line 8, the word retaliate is used. And to me, it's pretty broad. That word can be pretty broadly construed and might even creep into some First Amendment rights. Judges are often on our ballot. And my concern with this might be that somebody might run a campaign against
a judge or create a larger campaign in a community against the retention of a judge in a future election. Do you believe that the word retaliate could apply to such circumstances?
Ms. Butler.
Mr. Chairman, Representative Rodriguez-Williams, I don't believe so. I don't think that would be retaliation for a specific decision, but again, I'm not sure what that could look like.
Ms. Butler, Mr. Fuller gave us a number of staff comments. Do you have any reaction to any of those staff comments that might be helpful for the committee?
Mr. Chairman, I think the only addition that I would suggest to this committee is that the definition of judge should be broadened to things like to other judicial officers who are making those same kinds of decisions. So we have circuit court magistrates, we have district court commissioners, and there are also municipal court judges throughout the state. So that may be a consideration for this committee as well.
Thank you. Representative Oakley.
Thank you, Mr. Chairman. Briefly, I'm looking at, we talked last time again about, picking the right verbs to hit the conduct that we're looking at prohibiting. So intimidate, harass, retaliate. I was thinking about threaten. I know that to me, sometimes you start getting into prohibiting speech, that can be, so I just wanted to know if you had any thoughts on adding the word threaten as part of the list of prohibited conduct.
Ms. Butler.
Mr. Chairman, Representative Oakley, I understand the concern. I think the issue is difficult because that is a very easy way to try to influence a judge, just to threaten them. And I think we've seen it before. I mean, this is something that happens pretty regularly, I think, with judges. I don't know, how to walk that line between First Amendment speech and an actual threat. And there's probably some pretty good law out there to indicate where that line lands. But I believe it should be in there if somebody is threatening to come after me with a gun because of a decision that I made. I think that should be actionable.
Anything else for Ms. Butler? Seeing nothing. Thank you very much.
Thank you.
Anyone else in the room wishing to testify about this bill draft? Anyone online? Okay. Oh, we do have more comment. Good morning. Please introduce yourself.
My name is Loretta Howison-Callis. I am the Uinta County and Prosecuting Attorney. I'm also the Vice President of the Wyoming County and Prosecuting Attorneys Association. So I'm here to speak to you later today, Chairman Washut. But our association actually has discussed this bill, and since we do have a position, I thought I would share it with you. In relation to issues, we would agree with Ms. Butler that the definition of judge likely needs to be expanded. We do have municipal court judges that are dealing with daily confrontations and other issues that we believe it would be important to address. I would also point out to you all that we have hearing examiners for the Office of Administrative Hearings that are dealing with very complicated issues. Those issues are such as unemployment, workers' compensation, and other matters that do expose them potentially to some harm. You get people very upset. Anecdotally, so that this committee is aware, it was just only a matter of a few weeks ago, actually, that a judge was executed in his own driveway. And that was back east. And so these are matters that are pressing and current. He was executed by a father who did not attend a hearing, but he had removed custody from that individual. And that certainly is not here, but these are current and pressing dangers to our judiciary. And so certainly we do include that we have concerns related to their safety. With due respect for the neutrality of those individuals, however, it is the association's position that you should expand this at a very bare minimum to all officers of the court. That would actually potentially even include attorneys that are present in those, but certainly prosecuting attorneys, public defenders, and our clerks of district court. and our clerks of the circuit courts. You may or may not be aware that, I see lots of them right behind me. The angry public does not often have access to our judges. They have access to our clerks. And our clerks are the ones who are fielding those individuals and have the most need oftentimes for direct protection because of that communication. As to prosecuting attorneys, you have two very good prosecuting attorneys on your committee. I would note that I don't believe that there has been a moment in the last 8.5 years that I have not had an active death threat. And so it's just part of my job. There are times when those are taken more seriously. When I have had law enforcement contact me to determine my location because there was a present danger. However, that is something that I do understand and I've accepted that. However, it is something for you all to be aware of. When we are utilizing and executing our discretion is generally ethically to determine whether or not the facts of the case support a prosecution and what the nature of that prosecution should be. We do take an oath to uphold the law and to enforce the laws of the state of Wyoming. So when we are executing our prosecutorial discretion, it is not necessarily our options to not prosecute, and we are oftentimes prosecuting dangerous individuals. The only other comment actually just comes up from the question that was just brought by Representative Rodriguez-Williams related to free speech. You all have utilized in other statutes the use of the word malicious or maliciously, and you could probably qualify, would be just a suggestion, the physical a malicious retaliation or maliciously retaliate. There is case law that has interpreted, in fact, there's an abundance of case law, as Representative Oakley and Representative Crago could note. However, that term has generally been defined outside of murder cases as being either without legal justification or with hatred or ill intent. So if you utilize that, that would be to retaliate with hatred or ill intent or without legal justification. So it may be a good use of that qualification because it would likely not involve free speech at that location. With that, if you guys have any questions, I'm sorry, I'm a little nervous. I've never testified in front of you all before today.
Not every day we get to make a prosecutor nervous. Mr. Co-Chairman.
So, Mr. Co-Chairman, thank you. And I apologize, Ms. House, I missed the last little piece of your suggested language with regard to retaliation or threats. So I think I heard you say that it would help the language to say maliciously retaliate. But then you threw in the word hatred. Can you help me with what your thoughts were again?
And I'm sorry, I was probably prattling a little bit and sorry. Thank you, Chairman Washut, Chairman Landon. In relation to that, then if you wanted to qualify so that there was some protection to assure no prosecution of free speech, then my suggestion was you could say maliciously retaliate. And then what I was identifying is that there's case law from the Wyoming Supreme Court. Those judges have given us some parameters by which what we define maliciously as. So I was just identifying that outside of the parameters of premeditated murder or malicious murder, that has generally been defined as being either without legal justification or with hatred or ill intent. So that is a definition when you're using the word maliciously that you could have in your mind on why that might be an appropriate qualification.
Thank you for that. Appreciate it.
Representative Harold.
Thank you, Mr. Chairman. Thank you for coming and testifying today. And I'm wanting to kind of have a little bit of a dialogue. So you brought up this case of a judge that was executed in his driveway, which obviously it's sad that we're even having this conversation because what does the world come to type conversation. But let me ask this question, and this is just more so we can have the thought process. Would a law have saved his life, do you feel? Or do you think this individual was unhinged to the point where they would choose to go and track down a judge in their driveway and shoot him or hurt him I'm not sure how they executed him, but answer, because I think one thing we need to be careful of, yes, we want to bring protection, but we also probably need to understand too that legislating away or legislating immorality doesn't work. So just could you speak to that?
Ms. Callis?
Chairman Washit, Representative Haroldson, with due respect, we legislate morality every day. That is what the case of our statutory provisions are. And I wouldn't have a job if people would just comply with the law. Other than the fact that I'm statutorily required to have, I guess I wouldn't have any deputies or anybody else because I wouldn't have any need. However, in relation to those provisions, we do regularly, for example, have to prosecute individuals for intimidating a witness. And those come up fairly frequently. The anecdotal information I just provided to you is been from a security update from our court security. I don't know the specifics about the individual. I don't know other than the fact that in my personal observation over the last 23 years, oftentimes the judges are at the most risk for the non-criminal docket. Those family law cases are very emotionally driven, and when we're affecting children, that's going to be an issue. But the specific reason that you enact laws is generally to provide some general deterrence and hopefully provide for a momentary pause for individuals to stop and think that this has an extra issue. And in that circumstance, what I would hope, and again, I don't know the specific facts of that case, is that there would have been some indication or knowledge prior to the execution of a judge that there had been threats or some other kind of behaviors. We do have security meetings on a regular basis. We are aware of individuals that we have to have caution for. Our clerks have pictures of individuals that are provided by either law enforcement or their court security so that they have some awareness that this person may present a danger. And so the way that this statute that is being proposed would likely work is it provides for not necessarily like a minority report thing that we are trying to regulate issues. In order for an attempt, for example, there has to be some actual overt act is what we call it, an act towards the crime, not just a statement that I wish that person was dead, but some activity towards that event. And in this case with this type of statute, it is my anticipation that the reason that it's being proposed by the judiciary, and they can certainly speak for themselves, is that there's an opportunity to eliminate the threat after an overt act, but before the accomplishment of that activity. And so, yes, I do believe it could have a thwarting effect on that crime.
Thank you. Other questions? Senator Schuler.
Thank you, Mr. Chairman. Mrs. Callis, just a question on the definition of judge. If we were to expand it to municipal court judges, do you feel like that there are more threats headed their direction than some of the others like the circuit court or district court? Do you have any idea on data there or anything of that nature?
Ms. Callis.
Chairman Washit, Senator Schuler, my senator. In relation to issues, I don't have any data-driven information. Anecdotally though, most individuals do not have experience with the court system in the circuit or district courts. Luckily, a lot of people never get anything other than a municipal citation. And so they're certainly not addressing issues that involve matters such as custody cases, protection orders, serious criminal prosecutions. They have minimal jurisdiction as far as incarceration and fines and then some ordinance issues for their cities. Ordinances like county versus city. However, if you are intending to protect the nature of the judiciary, the honor and respect that they are to provide, then there certainly is those interactions, and they do come in with a large members of the public that is going to be their first line of defense. So that's why our association would suggest including the municipal judges. The more emotionally driven matters actually could be the hearing officers.
Thank you. Further questions? All right. Well, we look forward to you in the future topic. So thank you for joining us today. Anyone else wishing to testify on this bill draft? Anybody online?
Mr. Chairman.
Okay, I'm going to close public comment, bring it to the committee with your pleasure.
I'll move the bill.
Moved by co-chairman. There a second? Second by Senator Cooper. All right, let's work the bill draft. Any recommendations for amendments or on the staff comments? Representative Oakley.
Thank you, Mr. Chairman. So the first thing I'd like to discuss, I had noted this too, and I really appreciate Mr. Fuller, is taking out the attempt in the statute as we've got, as it's written. So that the conduct, retaliating, intimidating, harassing, I'd like to add threaten. That's another conversation. So the way it works in the law is, and Mr. Fuller has attempt in there. 61301 is an attempt, and that can be added to any crime. So you can, it's prosecuted in a different way, but you can add an attempt to any crime. So we can leave it as the prohibited conduct. And then if it were appropriate, the prosecutor can add attempt. So it actually limits it to for us just to use, to have attempt in there, I think limits it instead of like I say, the prohibited conduct. So I think we take
Specifically line and page for removal of the attempt.
I wrote it down. Page 4, line 37 was where Mr. Fuller has the. Page 3, line 8 is where it's in the statute, and then like I say, if you want to look at what we're talking about, that 61301, Mr. Fuller has it on page 4, line 37.
There a second to the motion to eliminate attempt, second by co-chairman. Discussion on the amendment. Representative Shostak.
I'm gonna suggest that we leave attempt in, even though there may be another way around it. I like clarity, especially for the public consumption. Somebody else might look at this and say, well, that judge wasn't intimidated. He ruled against me anyway, so therefore didn't commit the crime. So I think the attempt is what we're trying to stop. So I am opposed to removing the word attempt.
Further discussion. Mr. Co-Chairman.
So, Mr. Chairman, thank you. I appreciate comments by both the representatives. I'm trying to get arms around just what if a judge is not intimidated? If we have a judge that like me tries to let it roll off, is there a difference between an attempt to intimidate and whether or not we know that the judge was indeed intimidated? Does that make sense?
Representative Oakley.
Thank you, Mr. Chairman and Mr. Co-Chairman. Whenever you're looking at, you're putting a statute, and there will always be then the conduct that, the individual facts. All I can tell you is that, let's say that was the case. So you don't think they're intimidated. Perhaps the answer to that is then maybe it's not then maybe a 10-year felony wasn't committed. But let's say you do want to go forward and do it. All I can do is tell you that we can add attempt. Like that is already available in the law. So having it written as an attempt crime to begin with limits it, in my estimation. If what you're saying, the conduct was such that that prosecution is warranted and wanted and are going to go forward. And what you're saying is the person attempted to intimidate, even though it didn't intimidate the judge, then you add 61301. It's a different way of doing things you put both statutes together when you prosecute an attempt. So you say they did, let's say, aggravated assault and battery. That might be a bad one, but I'm going to use it. So, but let's say they just pointed the gun, which again, that could be aggravated assault and battery, but they attempted to. Then we just add attempt to aggravated assault and battery, put them together. That's how you do an attempt crime. So with what you're saying, it would be available. It is available to prosecute that way without having the words in the statute. You add them in how you charge it. Does that make sense?
Follow up.
So thank you, Mr. Chairman, and my apologies. I seconded without even really knowing exactly what we're doing with the language because I was anxious to get to the discussion on this. So I believe if we go to page 3, the person attempts to, if we take that out, then the language would simply be reading the person intimidates, harasses, or retaliates, plural. And then we can visit if we want to about a suggestion by the head of our prosecutors to add language on the retaliate. But I think that's how the language would read, correct?
Representative Craigo.
Thank you, Mr. Chairman. Just to follow up on Representative Oakley's comments, and I agree with her. This gets really into the weeds, and it's more complicated than just taking out the word attempts, because it change it from a specific intent crime to you could prosecute it without specific intent if you take out the word attempts. You may have, because if we leave the word in attempt, the person's defense could be, well, I didn't attempt to do that. I wasn't trying to, intimidate anybody. I was just doing such and such activity, and it just happened to intimidate the judge. Whereas if you take out the word attempt, then it becomes general intent, and it gives your prosecutors more room to actually cover the offense that may or may not be committed. So speak in favor of the amendment.
Further comments, questions? We're ready for the question. All right, all in favor of Representative Oakley's amendment? We have the language changes over here, including making the language plural if we take out attempt and all. Okay, we're good there. All right, all in favor of Representative Oakley's amendment, say aye. Aye. Those opposed, no. Okay, that amendment carried. Further, Mr. Co-Chairman.
Mr. Co-Chairman, thank you. And I don't want to forget that I do want to go back to the family language, but since we're on line 8, page 3, currently, and have just talked about this, I wonder, I'd like to learn more if other members of the committee have any thoughts of the addition to the maliciously retaliates versus just simply retaliates. And it looks like we've got an answer both ways here. So
Representative Craigo.
Maliciously? Yeah.
We should maybe let Representative Oakley go first. I just have a proposed amendment that I think deals with that issue without adding any additional language. It actually would remove some language. I think if we take out the words on line 7 or another action, and that would probably get to some of the concerns that Representative Rodriguez-Williams had, because in order to qualify for the crime, you have to do something by force or threat, and electioneering is not going to fall under that. So you could leave the word retaliate in there, but just take out or another action, which I'm not sure what that means anyways. I mean, I know there's obviously a staff comment in there, and Mr. Fuller referred to that. So I would propose that we just remove the words or another action on line 7 and put in the word or between force and in the word threats.
You have a motion by Craigo, second by Senator Case. Discussion on the amendment. Seeing none, all in favor, say aye.
Aye.
All opposed, no. We have that over there at the LSO table. Very good. Further amendments, Representative or Mr. Co-Chairman.
Mr. Co-Chairman, going to the top of page 2, family member definition means a parent, spouse, sibling, comma, child, or stepchild. That would be my proposed amendment.
Second by Kate. Okay. We have motion by the co-chairman, second by Senator Case on the family. You had stepchild, Representative Oakley.
Thank you, Mr. Chairman. Not specifically on the amendment, but it's certainly related here. I mentioned it earlier, obviously a policy decision, and I know it might be opposed. We heard a lot of testimony about the expansion of it. I think one of the things is that we need to keep it tight. I'm kind of in favor of completely eliminating the family member. And for example, when I asked about that, they said that's how you reach a judge. Well, then it is harassing, intimidating, or retaliating against that judge. If you use a threat about their family, that you are threatening the judge, you are retaliating, I don't think that that's some defense. So in the end, it's not about every family member. We're talking about a narrow set we're saying they need to be able to do their job. I think we're trying to limit this conduct to conduct against that judicial officer. So obviously policy question for discussion, but that's kind of where I'm headed, and I'd like to see if the committee agrees.
Further discussion on the co-chairman's amendment? Mr. Co-chairman.
As always, I really appreciate my prosecuting friend enlightens every time. I certainly understand where she might be going, but I guess in my mind, does that then become an implied? I kind of have the preference, as the representative from Albany County said, that we spell it out. I want our statutes to be understood by the public. I think one of the great ways to get to a judge would probably be through a family member. So if that doesn't exist in our statute, then I guess we do bank on our good prosecutors to say, well, that was a threat though. You threatened his stepchild or her stepchild, and I guess a little more conversation would help me get arms around that.
Representative Chestic.
Thank you, Mr. Chairman. I'm going to speak in favor of keeping the family member in. I want to talk some more about the stepchild piece, but if we take that language out, I think we would have to add some language in B on page 8 to include direct or indirect intimidation, because harassing or intimidating or retaliating against the family member is not a direct threat to the judge. It's an indirect threat. But I have a problem with adding, there's other problems. If I put direct or indirect in that language, that fuzzes it up and makes it crazy. I don't like doing that. I would rather be more specific with it. And I think keeping the family member is a better way of avoiding the other problems of putting in direct or indirect over on page 3.
Further discussion. Representative Rodriguez-Williams.
Thank you, Mr. Chairman. I support creating a special statute for just judges, but I have concern about sending a message that the well-being of the family of a judge is more important than other families in our community.
Further discussion. Representative Craigo.
Thank you, Mr. Chairman. I don't actually disagree with Representative Rodriguez-Williams about the family issue, but what we're really talking about here is using the family to threaten the judge, and the family just becomes the tool. We're not saying if you go threaten a judge's family that's any separate crime. If we go to one of the family members of any of our judges out here and threaten them for some separate reason unrelated to a case pending in front of that court, that doesn't qualify under this particular proposed statute. It's only if we go to their family members and threaten them because of how we were treated in the courtroom and our belief we were treated unfairly or whatever. So I think we have to leave the family provision in there because I think I agree with several of the other members. It just provides a little bit of clarity. I mean, reading it as a lawyer, I agree with Representative Oakley. Reading it as a lawyer and as someone who could prosecute that, yes, it would fall under that, whether the words family member in there or not. But because of that, I don't think it hurts anything to leave it in and just make sure that the statute's perfectly clear that threatening one of their family members in relation to a case is going to get you prosecuted under this crime.
Question for Representative Craigo, specific to the stepchild proposed amendment. it seems to me that once you go through the process of adopting a child and they become your stepchild, they become your child, right? So a stepchild is actually a child under statute. So is there a need to identify stepchild? Could you have a stepchild that wasn't adopted? That's the situation that we're trying to cover here? Okay.
Mr. Chairman, just to respond though, I can't remember I think there's multiple definitions of child throughout the statute. And so I think just for clarity purposes, it does not hurt to include it, but Mr. Fuller probably knows, for example, in the probate code, there's going to be a definition of child, and I off the top of my head cannot remember what that is. And then in Title 14, there's a different definition, and not all of them are exactly the same. And so to be honest, I don't know the answer to that.
Mr. Co-Chairman.
So, Mr. Co-Chairman, thank you. And I appreciate the question, and I can answer it just from a personal standpoint. I have 3 children, one of whom is not my biological child, but I think no less of that child than the other 2. In fact, I would tell the 2 male children, maybe I think a little bit more of her. I don't know. There's days that I do. So that's a situation, quite honestly, where she's not my adopted daughter. She's my daughter, but she's a stepdaughter. So I hope that explains why that I think is important. There are so many families out there where that situation exists. So thank you.
Representative Chesty.
Thank you, Mr. Chairman. I too have 2 stepdaughters who I consider daughters as much as my own kids are. Which brings me to the point I want to make earlier, and that is, do we need to add step parent and step sibling? Rather, you've added the motion on the floor only adds step in front of child, but maybe we need to add step parent and step sibling, because those are other family relationships that might be just as important to people as blood relationships.
Okay. Anything further on the stepchild amendment? Question being called. All in favor of Co-Chairman's motion regarding adding stepchild to the list? Representative Chesty.
Before you vote on that, is that a friendly amendment to add step parent and step sibling?
Mr. Co-Chairman.
Not at this time. I think we deal with
with
one, and then we can certainly take up anything else.
Okay. So vote now on the stepchild addition. All those in favor say aye. Aye. Those opposed, no. That amendment carries. Further amendments, Representative Chesty.
I would propose an amendment to add step parent and step sibling as well.
Is there a second? Second by Provenza. Discussion on the step parent, step sibling. Say none. I sense the vote. All those in favor of the amendment say aye. Those opposed, no. No. That amendment has failed. Further amendments, Representative Senator Schuler.
Thank you, Mr. Chairman. Also on page 2, I don't know if this will fly, but I would like to add municipal court judge after circuit court judge, comma. And really the more I thought about it, those folks I think would be more apt to have, even though we don't have the data for it necessarily, a chancery court judge, I don't think is going to see an awful lot of threatening and intimidation kinds of things, but I guarantee our municipal court judges, I've been in a few of those, and I think we might see a bit more there, even though we may not have the data. So I would add that amendment.
Second by Representative Oakley. Discussion on the amendment, adding municipal court judges. Saying none, all those in favor of the amendment say aye. Aye. Those opposed, no.
No.
That amendment passes. Further amendments, Representative Crago.
Thank you, Mr. Chairman. So during our last meeting, and I specifically asked Justice Finn about whether we could expand this to all judicial officers. What what we in the legal world call officers of the court, which would include attorneys, the clerks, and I have a whole laundry list of other things, other folks that I think probably qualify under this particular provision. And so I'm going to make that amendment. I'll read it out. And then if we get a second, we can discuss it. Page 2, line 4, judge would be stricken and replaced with judicial officer. Line 6, we already added municipal court judge. I would add district court commissioner, circuit court magistrate, district court clerk or his employees, circuit court clerk or his employees, hearing officer. And then the last one, and this is going to be conceptual because I think we need to put some sort of limitation on it, would be attorneys, because I don't think we can limit it to just prosecutors or people working out of the defender aide's office. It's got to be all defense lawyers at that point if we're talking criminal, but it also could be in the civil world. I mean, there are lots of clients that get very upset at their civil attorneys. It's not just the criminal realm. In fact, sometimes more so, to be honest with you. And I don't know how to limit that, but anyways, we can talk about that. And then on page 3, everywhere where the word judge appears, we would replace that with judicial officer. I think there's 4 of those. Line 8, line 9 twice, and line 10. And that's
you
my
provided that to the LSO, so they have a copy of it or not?
I'll be happy to.
Okay. All right. Do we have a second on the amendment? Second by Senator Schuler. Discussion. Mr. Co-Chairman.
Mr. Chairman, just as a point of order, I do think we may need to make some changes on page 1. Those would be conforming as well. Just to point that out.
Okay. Further discussion, Representative Kriegel. Your light's on.
Thank you, Mr. Chairman. So thank you for the second, so we can just talk about this. I obviously want to provide the protection to our judges. I truly believe they need it. They're not listed in our current statute. You know, there's an argument that they could be. I actually don't think they are. I don't read it that way. I think we need to do something. But at the same time, you know, we heard testimony today from our good county attorney. They experience the same threats on a daily basis. And I would probably tell you even more so than the judges. Clerks experience the same thing. Maybe not always at the same level, but they have issues in their offices too, and then there's really no remedy at that point. There's nothing we can do. Doesn't fit under any of the statutes. And if it does, doesn't rise to a level where it's going to have any sort of effect on the people doing it. They need to know that we're serious about protecting the folks in our judicial system. And so that's really what my attempt at this amendment is to broaden who we're going to protect, which in my mind needs to be everybody involved in the system. Thank you, Mr. Chairman.
Further discussion. At the risk of going off into the weeds, I can't help but think about our discussion last time about healthcare workers, you know, and other people who are facing, you know, nasty people in all sorts of circumstances. And I think one of the criteria that came up in that discussion about healthcare workers was that those were private sector employees. And so I have a little hesitation about including private sector employees who at a certain stage become officers of the court in the proceedings, but they're otherwise private sector employees. Representative Craig, want to respond to that?
Thank you, Mr. Chairman. Again, I said we probably may have to limit the inclusion of attorneys because they would be the only private sector employees listed on that list. Everybody else is a public employee. So some of the attorneys in the civil cases, they are going to be your only private actors, so to speak, in in my proposed amendment. Everybody else is working on behalf of the public.
Representative Provenza.
Thank you, Mr. Chairman. I having a little heartburn with the expansion of this bill continuing. I mean, I imagine that some of our other agency heads, I mean, we have the Department of Corrections Director, who I imagine also receives threats. I guess I'm just posing this question of how broad do we want to make this? And then a separate kind of, I guess, a question would be, will the conforming amendments then fix the short title with intimidate, because it says judges? Are we do we need to make changes to that, or does that conforming amendment just fix that as well?
Yeah, I think the title was what the co-chairman was getting at on the page 1, conforming amendments. Further discussion.
Mr. Chairman.
Ms. Co-chairman.
Just real quickly to finish up discussion, I have a lot of respect for the representative and certainly understand the intent of the amendment. I'm not going to support it today. And that is, I think this is an important step. I'd like to keep this bill as one step. And then, unfortunately, given what's going on in our society and our culture, we probably will be back here one of these days soon talking about trying to protect somebody else from what's going on out there. It's kind of heartbreaking, but I think we would be better served to keep our eye on the center of the target. And so I'll be voting against the amendment. Thank you.
Representative Oakley.
Thank you, Mr. Chairman. I guess just in response to that, I don't think that this broadens it in such, it clearly broadens it, but I mean, conceptually, when you're talking about the court processes, and in fact, when you think of it in that way, we've hit on pretty narrow, just taking the one person that's in the court process being the judge and only having it for them, when clearly we know, and the testimony is that the prosecutor, defense attorneys, some other attorneys that deal with it are every bit as likely to have that exact conduct happen to them. So in that way, as you said, while we're here, then maybe we should just get the whole thing and not just carve out one person in the system. So in that way, it makes sense to me. And like, to use your words, Mr. Co-Chairman, like we are here. So, I mean, the idea that it's just easy to come back and do a whole new one really isn't, this is a cumbersome process. So it seems to logically make sense to me to deal with it while we're here dealing with it, and include the actors that are in the system.
Thank you. Just a comment. I received an email from an individual about this bill, and he raised the idea that, or concern that the intimidation of a witness or a juror, that expires at the end of the case, and that this would be different in that this could occur after in terms of retaliation and so forth, but that, potentially jurors and witnesses might also be subject to that type of retaliation after the fact. So it's complex, but I think the primary focus was on protecting the judges, making sure that the officers in the other statute was interpreted to include judges, and there was discussion of whether or not the other statute did in fact include judges, and that's why we're here. So further on the amendment to expand to other court judicial officers. Anything further? Seeing none. Question on that? All in favor of Representative Crago's amendment, say aye. Those opposed, no. That amendment has failed. Further amendments to the bill draft.
Mr. Chairman.
Question being called on the
Mr.
bill
Chairman.
draft. Yep. Representative Jennings.
Yeah, I've been resident, wanted to find the right place to insert this. And I wanted to ask one of our judges. I'm a little surprised that we haven't seen this issue brought up, but we're the Judiciary Committee, and I think it behooves us to address things from an even higher level of rule of law. And having been the recipient of lots of things, you can't do that because it's not constitutional. I wanted to read just 2 sentences to you from Article 3, Section 27, that this committee ought to be very interested in. It says special and local laws prohibited. The legislature shall not pass local or special laws in any of the following enumerated cases. And there is a page full of those. But at the end of it, it makes a second sentence. In all other cases where a general law can be made applicable, no special law shall be enacted. I believe that with passing this law, if we were to do that, that we will be violating the Constitution on that, because every life is important. That judge's life, the clerk's life. Personally, I think the poor janitor might be at risk. He might be the one that somebody wants access into the courtroom. And so I see this, I'll be a no on this, not because I don't care about judges or the judiciary, but it's every one of those lives are important. And where do we stop? Where do we stop? Do we put legislative in? Where do we stop? How about law enforcement? They get threats all the time. And once in a while, somebody carries through with it. But from the constitutional aspect, like I said, I'm surprised we didn't have a constitutional memo on this, enumerating this very thing. We're not supposed to be passing special laws. Their life is no more valuable than that police officer that brought them into the court in the first place. And so I'd urge the committee to think about their oath of office where they swore to uphold this Constitution. And we were told not to pass special laws. 70 some judges are going to be the recipient of this, or 80, or I don't know how many that it is across the state. But that's a pretty special group of people. So anyway, thank you, Mr. Chairman.
Thank you. Okay, we're ready for the roll call.
Mr. Chairman, this is a roll call vote for 24 LSO 62, intimidating judges criminal offense as amended. Senator Case. Senator Cooper. Senator Furphy. Senator Schuler. Representative Chestick. Representative Crago. Representative Haroldson. Representative Jennings. Representative Nemec. Representative Oakley.
Aye.
Representative Provenza. Representative Rodriguez-Williams.
No.
Co-Chairman Landon. Chairman Washut.
No.
Mr. Chairman, we have 6 ayes, 7 noes, 1 excused.
Could you repeat that?
Mr. Chairman, we have 6 ayes, 7 noes, 1 excused.
Thank you. With that, committee, let's take about a 10-minute break. We'll come back in at 10:30 and continue on with our day's work. All right, call us back to order. Judiciary Committee. Representative Craigle.
Mr. Chairman, so following our last little debate and eventual vote, I'd like to make a motion to do a bill draft to insert the word judge without a definition in the existing statute, which is 65305. Statute already exists. It pertains to jurors, you know, and there was the debate whether the word officer applies to judge. And so for the time being, I'd at least like to get the word judge in the existing intimidation statute. And so I'm gonna make that motion if I could get a second.
Is there a second by Nemec? Discussion.
I think we may need to get a few more members back.
Discussion.
Mr. Chairman, is this a motion to sponsor a bill as a committee bill?
I believe that's the motion.
So Mr. Chairman, I would just note that, I mean, this is the committee's last meeting. There is no LSO bill draft with this provision, with this change. While there was notice given of the topic on, you know, of the general topic, there has been no notice on this particular bill draft that was included on the agenda. I think it's within the committee's prerogative to proceed how it wishes, but I would just note those points for the committee's consideration.
Point taken. Committee discussion on the proposed bill draft. Mr. Co-Chairman.
Mr. Co-Chairman, thank you. And I really appreciate the representative throwing that out for discussion. One of the bullet points as we began the interim, quite honestly, was this was included in what the Chief Justice indicated to us. The Chief thought was one of our priorities. And so any consideration we want to give to some alternative that perhaps accomplishes some of the same things, I think it's a good conversation to have. This was one of the priorities that was given to us by one of the other branches of government. And we spent 3 different meetings on this topic and brought it to today, and we didn't pass it. So thank the representative for at least having the conversation.
Mr. Chairman, if my apologies, if I just add one more point of consideration. 24 LSO 63, Ms. Adams just reminded me there was a bill draft that the committee looked at in September that did this, but the committee didn't forward it to this meeting. So I just want to, Ms. Adams was kind enough to correct me. I just want to make sure I mention that as well, that there was a bill draft at the last meeting, at least, that contemplated that change.
So is this a motion for reconsideration? Representative Craigle.
No, I don't believe so, Mr. Chairman. I was going to reference that we did at one point have a bill draft that we did consider as a committee. We decided not to do anything with it. And all it did was add the word judge to the existing statute. And I was just going to point out, I mean, one of the reasons I would rather go this route at this point is we're clarifying a statute, because some of us believe that you could prosecute under that particular statute using the word officer, but there is some concern by the judiciary that it's not clear. And so I think what we would be doing, rather than creating a whole new class, which is an argument, and I think it's a valid one, we're clarifying what we already believe the law to be. And so we're just adding the word in there, making it very clear that if you intimidate a judge under the existing statute, that it is a felony. And then the discussion on the rest of the judicial system, we'll have to have that on a different day. But I at least, you know, the last bill we talked about was obviously much broader, and it was, you know, a much bigger policy decision. I don't think this is much of a policy decision. It's a clarification of an existing statute. And I think that's how we would propose that to the larger body in March. Thank you, Mr. Chairman.
Further discussion. Representative Harrelson.
Thank you, Mr. Chairman. So I guess the question that I would have is, since I mean, I understand this was a bill we had, but with it not being on our agenda without public comment, the only reason I'm really asking is they kind of did this in ag and they shut it down and said, we can't do that because it wasn't, public comment wasn't included in that. And that wasn't something that we had that opportunity for. So what I don't want to do is get ourselves into this and find ourselves in a position where we're actually not doing something legal. And so public comment, it hasn't been on the agenda. This would be considered a new bill draft, even though it was something that we had on the docket before. It is a new bill draft. So I think that it would have to go back under public comment and we would have to have another meeting.
Further discussion. Representative Craig.
I happened to be at that ag meeting and actually we did vote on the bill. And the public comment rules only apply during session is my understanding. And that was the direction we were given by LSO. And we actually did vote on that bill draft.
Representative Jennings.
Thank you, Mr. Chairman. So, I think that might make a good amendment or a personal bill. I just think that even if LSO says that it's available, I think it's a bad precedent to start. We have these so that we can vet bills and so that the public gets to comment on it. And even if it's not challenged on the legal aspect of it, I think it's a terrible precedent to start. Come to the third meeting, the last couple of hours, and then, hey, let's do a bill draft. And I think it sets a bad precedent.
Further discussion. Representative Chester.
Thank you, Mr. Chairman. I would speak in favor of this approach. I do think it's a clarification. I can't imagine any world in which judicial officer does not include judge. So I think it's a perfectly good clarification. But also I think that the public notice has been fully satisfied because it's the same topic of the bill we just defeated. This is, and all the policy considerations that we talked about in this last bill, and anybody who want to speak publicly about that bill could have spoken, and those comments would be as applicable to this proposal as to the prior bill. So I don't see any procedural problem, any due process problem, and I'm in favor of this approach.
Further discussion. Representative Provenza.
Thank you, Mr. Chairman. Just, I don't know how I'm going to vote. I guess part of what my concern is procedural, but also, looking at the bill that was drafted, if you are in favor of the idea of the bill, there's some changes or amendments that should be made based on the discussion that we had with the last one and the amendments that passed, such as like we talked about, including municipal court judges. So if we are working 24 LSO draft 63, working draft 0.5 from the September meeting. And to be honest, I think a lot of my concern right now is that I wasn't at that meeting. And so I think just from the standpoint of sponsoring good policy, and that's the point that I find out of interim, is that I probably can't vote for a bill that I wasn't a part of the discussion on, and not knowing why that bill didn't come forth. So I'd like to know, I guess, from this committee, why we didn't bring this forward from the last meeting and we brought the other one.
Mr. Co-Chair.
Well, Mr. Chairman, a couple of things. First off, I think that bill did not come forward because the one that we just discussed for 2 hours did. That seemed to be the favor of the joint committee. And just in a general sense, committee, I think that each of us can decide on our own whether or not we have a reason to vote against the bill. I mean, there's plenty of reasons to always do that, and that's the easy way to go. But frankly, this is not out of protocol. This joint committee has considered that issue this interim and can bring this bill if we want to. Later on, we can work it during the session. If it happens to pass here, we can kill it during the session, which may be the desire of even some of the members of the joint committee. But the fact is, it's well within the purview of the chairman to consider an issue that was just considered in the second meeting. So I think it's a legitimate motion that's been made by the representative. Thank you.
So the chair is going to allow the motion, the will of the body is going to decide this. And if you think that it's an inappropriate bill to come forward at this juncture, you can vote no on the motion. Everybody clear? All right. Have a roll call on.
Senator Case, Senator Cooper, Senator Furphy, Senator Schuler, Representative Chestick, Representative Craigo, Representative Haroldson, Representative Jennings,
No.
Representative Nemec, Representative Oakley,
Aye.
Representative Provenza, Representative Rodriguez-Williams, Co-Chairman Landon, Chairman Washut.
Aye.
Mr. Chairman, we have 8 ayes, 6 noes.
Okay. Thank you, committee.
Mr. Chairman,
Representative Haroldson.
is there going to be, I mean, I don't know what we voted on exactly. Is there a way we can actually see what we passed?
Yeah.
It's easy to call up on.
You can pull up the e-notebook from September, or Representative Craigo.
I think, Mr. Chairman, if you pull up 65305A, all we did was add the word judge before the word juror.
And Mr. Chairman, we will pull that up momentarily on the screen.
All right, so I think we're clear. We just added one word to the existing statute. Now we move on to our next topic, which is the Rural Attorneys Program. We have a bill draft. That Mr. Fuller.
So, Mr. Chairman, 24 LSO 61, working draft 0.7, Wyoming Rural Attorney Recruitment Program. And Mr. Chairman, this is a draft the committee considered in September that would establish a pilot rural attorney recruitment program and provide funding for that program. Mr. Chairman, I'm happy to go through the bill draft once again if the committee wishes, or I can just hit kind of the high points of staff comments based on information that the State Bar submitted in response to the discussion in September.
Why don't you hit the high points?
Okay. So, Mr. Chairman, I would start just broadly, the Supreme Court, I'm on page 2, line 14, may establish the rural attorney program. The staff comment on page 2, in light of the discussion, it was noted a consideration of whether the Supreme Court or the State Bar should be the entity that establishes and operates the rural attorney program. Then moving on to page 3, line 10, this gets into the eligibility requirements for a county to participate in this rural attorney recruitment program. It includes a population limit. And then on page 3, line 10, has an attorney ratio. And the staff comment on the bottom of page 3 is language, is an alternative qualification. Rather than 1.5 licensed attorneys in the county for every 1,000 residents, it would be 1.5 qualified attorneys for every 1,000 residents. And then qualified attorney is defined really to mean an attorney who provides legal services to private citizens for at least 20 hours a week, and who is not a judge, prosecutor, public defender, clerk, in-house counsel, trust officer. Then moving on to move on to page 5. This was a staff comment that was a carryover. In selecting eligible counties to participate, the Supreme Court must consider a number of factors. And on the top of page 5, line 1 is the age and number of attorneys. And this was a carryover comment from the last meeting, whether that should be shifted to focus more on the number of attorneys rather than a consideration of age. Then moving on, the top of page 7 is the part that begins to spell out the attorney's participation in the program. It limits the program to 5 attorneys participating at any one time. Subject to available funding and as consideration for providing legal services, the attorney would receive an incentive payment in 5 equal installments. That incentive payment, I'm on the top of page 8 now, is equal to 90% of the College of Law's the University of Wyoming College of Law's resident tuition for 30 credit hours. Then on page 8, the Supreme Court makes each incentive payment to the attorney annually, and it divides the share of that payment on the top of page 9. So 50% would be funds appropriated to the Supreme Court, 35% of each payment must be provided by the county, and then 15% provided by the state bar. The participation in the program would obligate the attorney to practice full-time in the participating county for not less than 5 years. The staff comment on page 9 just highlights a number of considerations. First, whether attorneys participating in the program must live in the county in which they practice. Second, whether language is needed to clarify what it means to practice law in that county. The last 2 are points that were raised during the discussion in September, whether a local contribution or match should be required, or whether alternatives should be available for providing or meeting that local match. And then finally, whether a failure to repay should expressly subject an attorney to license suspension, or on page 10, line 23, as it currently is drafted, is just grounds for attorney discipline. The program will end on June 30, 2029. And in light of the discussion, another consideration for the committee is whether language is needed to make clear that attorneys who begin the program before the sunset date, if those attorneys have 5 years can complete the program after the program ceases. So there may be a need for clarifying language to clear that up. Page 11 appropriates funds for the payments for the 5 attorneys, and the bill draft would be effective July 1, 2024. With that, Mr. Chairman, I'd stand for questions.
Thank you, Mr. Fuller. Great work as usual. Questions for Mr. Fuller? Okay, well, we'll take it to our esteemed presenters from the State Bar, Mr. Gifford et al.
Thank you, Mr. Co-Chair. Mark Gifford, I work for the Wyoming State Bar. To my right is Kelly Neville. Kelly is a private practice lawyer in Laramie, and she has a long history of leadership in the State Bar. She's a former bar president. She is the treasurer presently of the Wyoming State Bar, and she also is part of our working group that is trying to promote rural practice generally, and this bill is an important piece of that. And to my left is Professor Alan Romero, who runs the Rural Law Center at the University of Wyoming College of Law. So this is really his passion. And he has done a lot of study in our rural deserts, our areas in so much of Wyoming that are underserved by the legal population. And he can talk to you at length about the benefits of putting a lawyer in these rural communities for service on boards, for representation. And so I will tell you that I've been working for the bar for 13 years, and this is the most tangible thing we have come up with to foster rural practice and serve the needs of rural residents in Wyoming, which is so much of our population. We have had something going in the bar for all this time, and we still have other things going besides just this bill. It's something that we believe in. We're trying to serve the needs of our public. And so this is an important piece of that. I want to hearken back to a witness you heard from in April. Pierce Peasley came and talked to you, and he's a young lawyer who came back to his hometown, Douglas, and he has tons of family support here, tons of connections. And even with all of that, after the overhead that he's able to share and everything else, he still makes about $50,000 a year. So I tell you that because this is not a lawyer welfare effort. This is an effort that is focused on meeting the needs of our public, the residents of small communities in Wyoming. And I think this provides a tangible way. We have, since the bill was originally produced, we've cut way back on the ask. This is a pilot program that requires the state to fund less than $200,000 to see what we can make of this program in 5 years. And if it's successful, we're going to learn some things along the way, tweaks that we need to make to this. But the fact that this is a pilot program, I think, is enormously beneficial and allows us to figure out if we can have the kind of success that South Dakota has had with their similar program. So with that, I'm happy to answer questions. Professor Romero does want to spend a few minutes talking to you about the constitutional questions that have been raised about this bill, because I imagine that those are on some of your minds. We think those can be adequately addressed. I'm happy to go through and give our position on the staff comments. I think they're really good comments, and I've got a couple of additional suggestions that I think will further those concerns. So unless somebody has a question for me or for Kelly or for Professor Romero right now, I'll just start through the staff comments.
Committee, any questions at this juncture? All right, let's go through the staff comments.
All right, staff comment at the bottom of page 2. We're fine with the state bar administering this program. We've got the resources to do that. We would bear the expense of doing that. And so we have no objection to putting administration from the court to the state bar. And we work with the court, as you might guess, on any number of similar things that go to access to justice and administration of justice. The comment on page 3 regarding alternative language, we do think this would add to the bill. Right now we have licensed attorneys in a number of underserved communities, but they're not practicing law. Just because a lawyer pays license fees to maintain their active license doesn't mean they're practicing law. And so this focuses in on the real needs of the community. What are lawyers doing there for 20 hours a week or more? So we think that's a very workable definition that will further the purposes of this program. On page 5, the staff comment regarding getting away from the age of the attorney, we think that's a constructive change and we would support that change. On page 6, this is not a comment, but I have a suggestion on page 6, the paragraph subsection F beginning at line 7. I would suggest the committee, if it's inclined to advance this bill, change that section to take out the limitation on agreements with municipalities, school districts, or nonprofit entities. I would remove those because there are other things that other entities that might step up that don't fit those categories. Law firms may be willing to kick in some money for this. So I would propose removing the limiting language on who eligible counties can partner with, because we think that will incentivize participation in this program by eligible counties. Page 7, this again, there's not a staff comment, but I have a suggestion for subsection A beginning at line 4 on page 7. As currently drafted, to be eligible, you have to be an attorney licensed to practice law in Wyoming. I would suggest you consider language that says, or is an applicant for admission to the Wyoming State Bar. That change would allow the program to take third-year law students and give them a path into a rural community as they come out of law school. And that's the model that really we're hoping that what we're going to do is seed these rural communities with young lawyers that are going to stay there for their professional lives. So I would ask the committee to consider that change. The staff comment on page 8. We don't really take a position on that. No opposition or one way or the other. Which gets us, I think, to the meat of the staff comments beginning at the bottom of page 9. Whether attorneys participating in the program must live in the county in which they practice, we think they should be required to live there. That's kind of the point of placing lawyers and not having the only option available to members of that community being telelaw, for instance. So we think our vision and what South Dakota has borne out is that attorneys are valuable members of the community. So we want them in that community. Whether language is needed to clarify what it means for an attorney in the program to practice law, I think we can hearken back to the provision on eligible counties, 20 hours a week in private practice. That's what we're trying to propose. And what that would do would allow a young lawyer or a lawyer new to the community to move in, take a part-time public defender contract, which will allow them to have that income, and then give 20 hours a week to private practice for fees. They're going to be incentivized to grow their private practice in those communities. And so that's going to be kind of self-incentivized. Whether a local contribution or match should be required, we think it should be required, but give the local entities a chance to partner with other interested people that are willing to bear part of the cost of the program. So we would like to see it continue to be a requirement for the local contribution. Whether a failure to repay an incentive payment should trigger discipline or just suspension of the lawyer's license. As the disciplinary counsel for the Wyoming State Bar, I favor the suspension route. And the reason for that is there is a statute on the books right now that says that lawyers who don't pay child support can have their licenses suspended. That is more clear cut and provides exactly what the consequences are going to be if a lawyer doesn't live up to their repayment obligations. Because discipline, there are a lot of things that discipline can take on: a private reprimand, a public censure, a disbarment. I think the straightforward path of providing for suspension is cleaner and avoids other issues. And we do have a comment on page 11 about clarifying to make clear that if this sunsets, the lawyers that are participating in the program will continue to receive the payments. So that's an overview of our position on the comments. And I don't know if there are questions about my testimony here, but I would like to leave Professor Romero some time to address a couple of issues, including the constitutionality.
Yeah, we'll certainly provide opportunity for Professor, but any questions? Representative Oakley.
Thank you, Mr. Chairman. Just really quickly, when we were talking, you were talking about the clarifying what it means to practice law, and you talked about 20 hours. Do you think it's necessary to define that? You know what I'm saying? Like, I mean, whether it's 20 hours, is that getting in a little too prescriptive rather than just a question?
Mr. Gifford.
I don't know that we can define it any better than we've defined it in that other comment. I will tell you that I think requiring some certification, annual certification from a lawyer, that they are meeting that 20 hours a week. We don't want to micromanage and we don't want to get in there, but I think we're going to know when the rubber meets the road on this, is the lawyer providing legal services in that community or not? And if the lawyer isn't showing up and is a no-show and you know isn't doing the work that they've taken the stipend to do, I think we're going to know that, and to provide the certification from them on an annual basis will, I think, give us the enforcement mechanism we need.
Mr. Gifford, I'm curious, what would you say to that other attorney who works in that underserved county who doesn't participate in this program, has lived there for the last several years, and suddenly we're going to incentivize some new person to move in and open a practice in competition with that attorney, and we're going to subsidize them to do so? What would you tell that other attorney?
what I would expect from the established attorney in the community is that nobody would be happier to have another lawyer in the community. I mean, these folks in the small communities are stretched so thin, they're turning things down for conflicts all the time. Nobody's going to be more welcoming of this program, I think, than the established attorneys. Because in the total scheme of things, a stipend of $16,000 a year, it helps. It's a boost, but it doesn't establish your practice. This gives you a way to get into the community and have an established practice.
Representative Chester.
Thank you, Mr. Chairman. Mr. Gifford, I also have a question about the comment on page 9 and whether how do you define practice law full-time in the participating county? Would you be interested in or consider having an office as the marker that you must have your primary office must be within the county for, and maybe that you could have a requirement that the office be open to the public for 20 hours a week or whatever? Would that be what I'm concerned about is somebody is sitting in a small town and has a case from the next county over, but is still practicing law while sitting in, does that count as practicing law in the county or not? I think it seems to me a brighter line is having an office open to the public at some point.
Mr. Gifford. Mr. Chairman, Representative Chestic, I think that's a great suggestion. That underscores the need for a physical presence in the community, and I think that's a really good suggestion.
Further question? Senator Cooper.
Here, I'd see a real need for this in my counties. 3 of them were extremely underserved. Personally, in the last 10 years, I've been through 3 attorneys because one took a judgeship, one took a job in the private sector, and the third one just left town the other day. So it's an ongoing issue. So, but back to my question being the 35% provided by each county. It says county. Does it really matter where that money comes from, as long as it comes from within the county? Is it a county responsibility or any other entities, or can it be a private donation, or where do you see that going?
Mr. Gifford. Mr. Chair, Senator Cooper, that was behind my suggestion that we open up where the county contribution can come from. I think we still need to channel it through the county for administrative purposes, but where the money, what pocket the money actually comes out of, it can be a school district that wants to have a lawyer in the county. It can be a nonprofit. It can be a law firm that decides to kick in a couple $1,000s to fund that 35%. So that was the intent of that suggestion.
Further discussion? Representative Jennings.
Thank you, Mr. Chairman. So mine's just a simple one. I just want to play off the chairman's question a little bit because I don't know. I haven't found any lawyers that really want more competition. And I haven't found really any constituents that come and said, boy, the one thing that we really need is more lawyers. And so could you provide us with some people that, in the small communities that, would testify and say, boy, we sure wish that we could have some subsidized lawyers coming here. Do you have any of that?
Mr. Gifford. Mr. Chairman, Representative Jennings, thank you for the kind question. I will tell you that one of the things I do as bar counsel is I man an ethics hotline. So I take calls, dozens of calls every week from lawyers with any kind of problem that they're looking for guidance on. Over the last 10 years, there's been a steady drumbeat of small town lawyers that are just begging for somebody to come in and take over their practice. So that's kind of an indirect answer to your question, is that we know that there are lawyers that are transitioning into retirement and they can't find a lawyer to serve their clients. So that's a lot of the incentive for this program. And I'm a baby boomer. I'm part of the silver tsunami, and I'm not getting any younger. And what I'm seeing is colleagues that I came into the profession with are dropping out. And in small towns, there's nobody to step up.
Follow up, Mr. Chairman. Thank you. But Sir, wouldn't you also think that that could be said of doctors, of plumbers? In our smaller communities, we're lacking on mechanics. I mean, where do we stop with this? You see a conundrum there? I mean, is government going to subsidize every one of these groups or just lawyers?
Mr. Gifford?
Mr. Chair, I'd like, this is something that Ms. Neville and I have talked about. What is the difference between lawyers and plumbers and mechanics? And I think she's a lot more eloquent to address your question than I am.
Ms. Neville?
Thank you, Mr. Chairman. Representative Jennings, I mean, I think that we do subsidize doctors and dentists millions of dollars that the state puts in because we feel like medical care for our citizens, regardless of how large their community is so critical. That your health is a very critical thing. And I think it's important to focus on what service is being provided. And I love my plumber, very important person in my life. My mechanic, all of those are very important. I think though, when attorneys are looking at constitutional rights, ability to see your children or to protect your children, to protect your property, to help your parents when they're in need and they're aging. And there are so many really important rights and abilities to just function in life that come down to the judicial process, and that lawyers help members of the public with, and that our people in smaller communities are suffering. I mean, we have a hotline also for lawyer referrals, and there is such a shortage. That hotline is getting calls, like up to 40, 50 calls every day asking for help from lawyers because they cannot find someone to help them. And so there's a huge need. And I would say that's members of the public reaching out saying, this is a huge need we have, please help us. And this is just one of multiple responses that we're working on to try to address that need for the public.
Representative Rodriguez-Williams.
Thank you, Mr. Chairman. Mr. Gifford, so we're talking about one strategy to address recruitment and retention that the bar is looking at through this draft bill. Can you tell me a little bit about whether or not our bar exam for the state of Wyoming is in line with other states, and if there's been any discussion as to changing that to make it more in line with neighboring states?
Thank
Mr. Gifford.
Mr. Chair, Representative Rodriguez-Williams, I welcome the chance to address that. Wyoming is one of 44 states that gives the uniform bar examination. That's essentially a national exam. When we first adopted the uniform bar examination in 2012, we were the 9th state to adopt it. And we're on the cusp now. In a couple of years, the entity that puts out the bar exam is called the National Conference of Bar Examiners. They are redoing the exam altogether into what's going to be called Next Gen Bar Exam. And it's aimed more at a clinical approach to that young lawyers coming into the practice have the actual skills to be a lawyer, versus the present bar exam, which is how good is your memory and how well can you write. So Wyoming has been very active in admissions nationally. We have a member of the Wyoming State Bar who's going to be the incoming president of the National Conference of Bar Examiners. We have other members of the bar that are heavily involved in the admissions process, and I think we're right on the cutting edge.
Representative Harrelson.
Thank you, Mr. Chairman. So real quick question, do we have a number, like how many active members of the bar are there in the state of Wyoming? And what are we looking at as far as you said that silver tsunami? Do we have an idea? Do we have those numbers of where we're going to see in the next 10 years that retiring out, and kind of what that vacuum may look like?
Mr. Gifford.
Mr. Chairman, Representative Harrelson, we do have, Professor Romero will drill down more on this. As I said before, to hold active status, all that means is that you pay $355 a year on your license fees. That doesn't tell the bar anything about how much of your time are you spending practicing law. In Wyoming, we've presently got about 1,800 lawyers in state who hold active status. That means they're eligible to practice law. Whether they do practice law is a completely different question. So a lot of the effort of Professor Romero's studies and our efforts to get out and find out who in this community is engaged in the active practice of law. We had some communication with a lawyer in Afton, and we show that in the Afton area, there are 10 lawyers. And his question is, well, who are they then? Because I don't know who they are. And so part of the effort of this program is to really identify what these rural communities, are they being served at a level of 1.5 lawyers per 1,000 people? And that's what we're going to have to do, is really find out what comprises that 1.5 lawyers.
Follow up. Thank you, Mr. Chairman. Second part of it was that retiring out age group.
Mr. Gifford.
Mr. Chair, Representative, we know that the percentage of our lawyers who are over the age of 60 grows by the year. When I first started at the job, there were about 25% of our lawyers, members, who were over age 60. Now it's over a third. We're heading up towards 40%. So you can do the math as I can. We know that it's coming. Can we drill down further on it than that? How many lawyers stay in practice longer than maybe they should because the economy is forcing them that way? There's no way, I think, to put a fine point on it other than we know what the trend is going to be.
Okay, so Professor Romero, let's talk about this constitutional issue, which is giving me some heartburn.
Thank you, Mr. Chairman. May I respond to this most recent question about
Certainly.
numbers? Because that was one of the projects that the Rural Law Center undertook. And you might recall, and if you're interested, you can still see in the meeting materials from the last meeting, a report that details the 8 counties with the lowest attorney to population ratios. And it includes an estimate of the retiring numbers in those counties. And for 3 of those counties, it was a third of the active lawyers that were likely to retire. And we were very conservative. It was only if they said so, or there was some other objective indicator that we didn't do it based upon just age. So it's probably higher than that. The lowest percentage, well, I think there was one county we didn't identify any prospective retirees, but although there probably are, but it generally ranged from 10 to 33%. So it's a significant number, but even not counting the retirees, in those 8 counties with the lowest attorney to population ratios, they're already under 1.5 per 1,000. And I guess while I'm commenting on that too, I'll just add that the amendment that's included in the staff comment revising the ratio to count qualified attorneys would add 5 additional counties, and so possibly a 6th, because we didn't do the research on the counties with higher attorney to population ratios, but all of the counties under 25,000 other than Teton and possibly Sublet would be included with that change. Okay, Mr. Chairman, on the constitutional question, I will just comment very briefly with the invitation to talk about it as much as you'd like. My professorial inclination is to want to offer support and authorities and to quote cases, which I can do and would love to do if you want to hear it. But what I'll assume is you want shorter and briefer, and then happy to talk about it more. But yeah, since it is a substantial question, an important one for a legislative body to consider, and it's been raised, I'm glad for the opportunity to address it. The Wyoming state constitution includes a clause that says that neither the state nor its political subdivisions may make donations to or in aid of any individual, association, or corporation, except for necessary support of the poor. The Wyoming Supreme Court has not clearly interpreted it. They have addressed it a number of times, but they haven't said clearly what they understand that to mean and when it applies, which does make it harder to feel confident about its application to this bill. But there are two prevailing interpretations of these clauses, which are very common across the country. Wyoming's was verbatim from New York and was adopted at the very same time that North Dakota adopted theirs. And North Dakota, by the way, has a program like this, and no challenges have been raised to it. But the two interpretations are, one, like in Montana,
the rule is simply that it just requires that there be a public purpose, that it not be for a charitable or donative purpose. And I think that's the most likely interpretation in Wyoming, because 100 years ago, the Wyoming Supreme Court addressed the interpretation and application of the Wyoming Donations Clause in a case where it was a tax exemption for veterans and widows, war veterans and widows, and the court in that case said, we conclude that this is for a public purpose, and that's all we have to conclude to find that it doesn't violate the Donations Clause. So I think right now Wyoming would be counted in that group, and obviously, as we've already described, this is not for a charitable purpose. It is for a public purpose, to provide public access to legal representation, an undoubtedly permissible and important public purpose. But the other interpretation, and the most common, is based upon the word donation itself, right? The North Dakota Supreme Court a few years ago, identical clause, looked at contemporary definitions of donation, concluded that it meant then what it means now, which is, a payment without any consideration. And consideration includes a promise to do something you're not otherwise legally obligated to do. And in this bill, that certainly would satisfy that requirement as well, because the participants are obligated to contractually commit to practice full-time for 5 years in the underserved county, the eligible county. And so either way, I think there's no significant question about the constitutionality of the provision at all. One other question I'll comment about in 30 seconds, I think, is just the Supreme Court's ability to address that issue if they are administering the program. And that's inherent in the judicial branch, that the High Court of the state determines the scope of its own authority as well as the validity of its own rules. Right? The Supreme Court has authority to adopt and promulgate rules regarding the profession and so on, and they have to and do consider the challenges to the constitutionality of those rules. But administering a program does not disable the High Court from evaluating the constitutionality, whether it's this clause or some other constitutional question that might arise. May I also comment about one other?
Please.
One of the other staff comments. Thank you, Mr. Chairman. Thought maybe it'd be worth elaborating on the resident requirement. Whether it's required or not, I think is probably not important at this stage for a pilot program. In the other states that have done it, they've been resident, even though it's not required in the statute, the implementing statute. So I think that's likely anyway, almost certain anyway. But I think it's certainly consistent with the purpose, right? So I think it would be a good addition to emphasize that one of the primary objectives comes from having a resident attorney. Obviously, reducing distance between clients and attorneys is an important objective, but it's much more than that, and it emphasizes the public purpose of this. Coming back to Representative Jennings' question earlier, right? That a resident attorney provides benefits beyond just providing legal services. I commented in April about one study that found a 1.6 economic multiplier for resident attorneys, but more recently I've seen some other both examples and research that I thought I could at least briefly share with you. One is a participant in South Dakota who quantified the direct economic benefits of her service in the eligible county under the South Dakota program. And even just counting the savings to the county from her criminal appointments and not having to hire somebody from outside of the county, helping with mental illness commitments, pro bono services, and those kinds of things. Even those direct benefits totaled more than $10,000 a year, which is 2/3 of the stipend she's receiving to begin with, and doesn't even begin to count the economic benefits that come from legal practice generally, right? Facilitating business transactions and so forth. Economists at a recent conference that I attended have a pending publication that attempts to quantify it, and their findings are that equaling the access to justice in rural counties would produce a $27 billion economic stimulus in rural America. That's over $15 million per county. It is most certainly not a charitable kind of purpose. It's recognizing the centrality of legal services, certainly to life and liberty. You know, criminal law and family law are two of the most, they are the most critical needs in our rural communities in our state, according to our surveys. But also simply for economic activity. Lawyers are essential to generating wealth. And I think from that perspective, it's a wise public investment to facilitate service in these underserved communities.
You have more?
Mr. Chairman, of course, but I'm, but yeah, I think we've commented about the most important things. I'll just share my perspective, which is that because it's a pilot program, I think a lot of the details could wait to be addressed subsequently. The bill, even as it is, I think would be a great step in the right direction, give us an opportunity to build some momentum and evaluate what kind of effect it might have for our state.
Very good. Representative Jennings.
Thank you, Mr. Chairman. So I have two quick questions, if I can. So the first one, Professor, is how many people do you think, I mean, you've done some studying, how many people would affect, say, in the first year, might sign up for this subsidy?
Yeah, Mr. Chairman, Representative Jennings, I think that there would be great interest. Now, the challenge is connecting that interest with opportunity. But I would expect that we would have more than 5 applicants. When I have surveyed the class, more than half expressed their interest in serving in an underserved Wyoming community if they were to receive this kind of financial assistance to get started in a practice.
So follow up? Yeah, Mr. Chairman, I just wanted to get the number right before I ask the real question.
Yeah.
So 5, 10, 20, probably not 500. Okay. So I don't, Mr. Chairman's follow up. So I had some fairly good success earlier to some degree. In our Constitution, we are told the legislative that Article 3, Section 27 says the legislature shall not pass local or special laws in any of the following, and then it goes through the whole thing. And then at the end, it says, in all other cases where the general law can be made applicable, no special law shall be enacted. So if you were doing your legal constitutional aspect to us as legislators, and we're going to enact a law that only, let's say, 50 people are going to be affected by this law, would you not see that as a constitutional conflict for us as legislators enacting a piece of legislation that only affects, I mean, I like visiting with you guys, but maybe we could broaden it out and gather up, plumbers and bring in a whole bunch of people. So we're not just talking about 5 or 50 people. You see a constitutional conflict?
Mr. Chairman, Representative Jennings, I do not. And part of that, well, I guess the entirety of the reason why I don't is just my understanding of what a special law means in state constitutions. Those provisions are universal. I think every state in the country has one. They certainly don't, and it's evident from, legislation here and everywhere across the country. They don't prohibit legislation that affects only a subset of the population, even a small subset of the population. So while on the face of such a provision, the text might suggest, well, anything that's not general is special. The understanding of such clauses is not so broad and restrictive on the legislative power, because of course legislatures aid various kinds of industries in various kinds of ways. They pass laws that apply to only subsets of the population. of all kinds. The prohibition on special legislation is the avoidance of discriminatory or irrational treatment, whether it's benefiting or burdening. And here the benefit to be provided corresponds precisely to the objective, the public objective that justifies it, right? It is not selecting a subset of those who are so situated as to provide the desired effect. The desired effect is to attract and retain rural practitioners for a valid public purpose. And a legislative act that facilitates accomplishment of that would not violate a special law, a constitutional provision.
Mr. Senator Cooper.
Thank you, Mr. Chairman. Professor, in my district, I would say that 100% of my constituents are underserved, even though 2 of them are in counties that may not qualify. The portions of my district that I serve are definitely underserved. Wouldn't you consider those constituents to be beneficiaries of this law?
Mr. Chairman, Senator Cooper, most certainly. I think that is a way of describing how a legislative act that serves a valid public purpose is both a valid exercise of the legislative power generally, but also is compliant with the special legislation prohibition, which is meant to avoid legislation which is not public-minded. And certainly the recipients, from a policy perspective, the beneficiaries are not lawyers. They'll work somewhere, whether they work in Washakie County or in Denver. The beneficiaries are the people that they will serve in those counties if they are assisted in moving to and practicing in those areas.
All right, Mr. Gifford, would you bring us home, and then we'll see if there's other people in the room that want to testify on this.
Again, Mr. Chair, thank you for carving out time for us now, 3 different chances to visit with you. I think the process is working. The bill continues to get better. You ask good questions when we try to address those, and I would just ask for your support in advancing this bill forward, because I do think these problems in our legal deserts, our rural underserved communities, aren't going to get better. They're going to get worse over time. And this is an effort that is tangible, that will allow us to learn how the most effective way is to put lawyers in those communities that are losing lawyers with nobody to replace them. So thank you very much.
Thank you very much. Others in the room who might wish to testify on the rural attorneys, please come forward. Thank you very much. Please identify yourself and tell us what you'd like us to hear.
Mr. Chairperson, my name is Heather Jacobson, and I never get to say this statement, but I'm going to look at Representative Jennings and say, I'm exactly what you're looking for, what you asked for. I'm a lawyer here in Douglas in private practice. I'm a sole practitioner, and I think that we desperately need more lawyers here in Douglas. And I came to speak in support of this bill to make that clear, because I am the person that wants more competition, and I have to turn away somebody every morning and every afternoon. And I'm hard to find. I don't advertise. I don't have a web page. If I could have a private phone number for my office, I would. And I still turn away somebody every morning and every day. And each one of those people that I have to turn away, I think would also be sitting here to testify if they knew, saying that, yes, we need more attorneys in this town. They may not want to say it publicly because everybody will make fun of them. But when they are in that crisis and they call me, they desperately want other attorneys. And I think that we're in a different position here in Converse County, so that everybody knows If you look at the state bar website, it appears that we probably have 15, 20 lawyers here in Converse County. In reality, we have 3 lawyers in private practice, and that's it. Everyone else works for the government or is retired, and that's it. And then also additionally, I'm the only attorney that's solely in private practice, because people think about private practice in terms of doing divorces, doing criminal law, but somebody's got to represent the town of Douglas. Somebody's got to represent the town of Glen Rock. Somebody's got to represent the Fair Board. None of this is taken care of by government lawyers. These are all private lawyers that have to be able to step into that realm. And do you want somebody representing your Converse County Fair Board that is from Casper? You don't want those. You want somebody that's a resident of your county and knows your county and is willing to practice in your county. And so I think that if Converse County suffers this problem, and I would say Converse County probably has a higher average net income than 90% of the counties in the state of Wyoming. And so if we have this problem, I can't imagine what happens in Lusk. I can't imagine what happens in Crook County. I can't imagine. Well, I know what happens in Washakie County because I get those phone calls too, even though I practice here in Douglas. And so I think that this is something that all of these counties desperately need. I also want to make absolutely certain of my conviction on this. The reason that I found out about this bill was because it was mentioned by Mr. Pierce Peasley with donuts with the judge one morning. That's the only reason why. I haven't had anything to do with the working group. I have had nothing to do, no communications with the state bar or Mr. Gifford. Nobody's asked me to be here today to testify to this fact. I came on my own initiative. The only reason I knew you were meeting here in town is because the Douglas mayor / my personal trainer mentioned it in passing. And yet I still came to testify because I think that you needed to hear this perspective today. And I think also additionally, the fact that Pierce Peasley, who would be the direct competition of whoever would benefit from this program, attorneys wise, still came and testified and thought that this was an excellent idea to you. I think that that's even further support that those of us that could otherwise be viewed as competition are fully in support of this.
Thank you very much. Very helpful. Questions? Representative Jennings.
Well, Mr. Chairman, I feel compelled to respond for some reason. Ms. Jacobson. So not to be completely misunderstood here. I'm not saying that there's not a problem here, although sometimes I wonder, because there's at 2 o'clock in the morning, it might be a plumber that I really need, But that having been said, what I hear out of that is that government lawyers are in direct competition with the private sector. And I mean, when you're describing what's happening in Douglas, that's one of the major concerns that I hear is that there's nobody in private practice. And I'm not saying that I don't understand that there's a problem, but it's across many sectors. Would you agree that employment it's a problem in plumbing, carpenters? You can't get enough of anybody. And well, there might be something that I've missed. But the question becomes, do you want government subsidies? Do you want government entanglement to solve a problem where the free market is really the best answer? And do you feel like that your fellow citizens should have to be subsidizing your particular occupation? I'm not at all arguing that there's not a problem. Baby boomers are going to retire and we're going to have a problem. We're already having a problem. Just go eat lunch. You'll find lobbies closed in your fair town that they can't find workers. And so I guess my question to you is do you feel like that government getting involved even further here is an answer? And instead of free markets and entrepreneurship and there's other ways of addressing this than just the government throwing subsidies or money into it.
Ms.
Your response.
private market fix the problem?
Mr. Chairman, for those of you who don't know, I actually have a master's degree in economics, so I'm with you on the fair market there. However, what we're seeing playing out in these rural communities is that the fair market isn't fixing it. And it's not like a plumber where your choice is either pony up the money to have your pipes fixed or live with it or do it yourself. I would think that any of the judges, district court judges in these rural communities desperately would like to get rid of the people doing it themselves and harming themselves and harming their entire lives because of this. So while the plumbers and the tradesmen of this country are incredibly important, I think that it's very different because of the idea that your argument is that we're going to let the perfect be the enemy of the good. The desire to not help anyone is not going to help these rural communities. And so I don't think that that is, in a perfect world, yeah, fair market economy would handle this, but it's not happening. And those people who are not working, a lot of times part of it is because they're in the legal trouble, whether it's not able to get child support, not able to get out of jail, of all of those things. So that leads to all those other issues that you're talking about additionally. So I think that saying that it would be good if we could help everybody or nobody is not realistic, and that we need to help where we can.
Okay, Senator Cooper.
Briefly to respond to Representative Jennings here, there's been several times that I needed a lawyer at 2 a.m, much more than I needed a plumber. But would you say, Ms. Jacobson, that what? Do you see any?
Was I there?
Yes.
Would you see any difference from this program to what we do with doctors and other professionals to try to draw them into the state?
No,
Ms.
I
Jacobson, if you know.
don't. Oh, sorry. Mr. Chairman, I apologize. No, I don't.
Okay, thank you. Anyone else in the room wishing to testify? Very, very appreciative. Okay. You can both come up, yeah.
Expedite process.
Yeah, it's. Somebody mentioned lunch and now we're starting there. Okay, so please introduce yourselves and let's move through.
Mr. Chairman, members of the committee, I'm Marcia Sheener with the Wyoming Trial Lawyers, and I was just going to add just a very short couple of things. Representative Jennings has made a few comments that I thought were worthy of some response. In particular, family law, folks needing family law attorneys are having a very difficult time in the state of Wyoming. And we get calls all of the time, and you have family law lawyers who practice in Cheyenne who are traveling to my part of the state, which is Thermopolis and the Bighorn Basin, trying to help these folks. Also, you heard earlier this morning about the Navigator program, which the Supreme Court is putting into practice to help people who are representing themselves. And because people can't find, especially family law lawyers, they're representing themselves in court. They are doing the best that they can to navigate a system which is complex, difficult to understand, and time consuming. And they are trying to take care of their children, custody issues, child support issues, divorce issues, and others. And that also holds up our court system. And so I think that those folks, if they could be here today, would let you know that they would really welcome additional lawyers in these communities. Also, we just interviewed a judge for our magazine who mentioned practicing in small towns, getting his feet on the ground, knowing his community, all of those things, county commission, other boards contributed to his wanting to become a judge in that community. So it's a circular thing. So you have lawyers who are invested in their communities and who eventually will become the folks who sit on the bench. And just a couple little things to add to the discussion. Thank you.
Ms. Callis?
Thank you. Again, Loretta Howison Callis, Una County and prosecuting attorneys. Or prosecuting attorney. I am not speaking for the Prosecuting Attorneys Association. I'm speaking as an attorney that lives in Uintah County. Chairman and members of the board and co-chair. We have a representation desert in southwestern Wyoming. And it is of a crucial nature at this juncture. And so I do strongly hope that you pass this through so that there can be discussion on the floor. And I hope that this bill passes. I hear Mr. Fuller sometimes talk about napkin math. So I'm going to give you some napkin math, and it's somewhat what Mr. Gifford has said. If you look into the state bar, they're probably going to say there's somewhere around 18 lawyers in Uintah County. Maybe a couple more that I'm not thinking of off the top of my head. But out of those 18 lawyers, that's a population of in excess of 21,000. The last census was just under 21. And we've had an influx of people moving into our communities for a number of reasons, including economic development. Of those 18 lawyers, 6 of them are full-time government attorneys. And when we're talking about competing, Representative Jennings, we don't compete against the private sector. I desperately need 2 more prosecutors in my office. I have 2 attorneys that are handling those cases. My personal felony docket is 180 plus cases a year. And so certainly that is my focus in addition to representing the county. Similarly, the public defender's office currently has an open position, and they have had that position for over a year as well. However, as noted by Ms. Jacobson, there are 2 other attorneys in that 18 number that are limited into their practice because of contracts for guardianship corporations that they represent juveniles and juvenile proceedings, city attorneys, and likewise, as well as our city judges. There are 5 of those 18 that are actively retired that are going to be showing up as active in our bar. And so they are not practicing, although because of the extreme need we have in our community, those individuals keep coming back and keep having to represent people because they just can't say no when they have these people desperately asking for help. And finally, one of those 18 is a corporate attorney who does not take private cases. And so that really leaves you down to 4 attorneys for 21,000 people. And in that fact, there is the fact that 3 of those 4 attorneys are in one firm. So that means we effectively have 2 attorneys for 21,000 people in Uintah County. So what that effectively means is that whenever we have people that we need to have representation, I'm referring them to people in Laramie, Sheridan, Cody, and they're getting charged $200, $300 an hour for those attorneys to drive to Evanston so that they have representation. My drive here today was 5 hours. So that by itself, before I enter an appearance in court, is over $1,000 that those people are having to pay. So they have to make those critical choices. And some of the other inquiries that have been made, I heard Representative Haroldson, for example, what are the ages of those attorneys? Out of those 18 attorneys, I don't want to offend anyone, so I'm going to say over 50. I believe there's at least 6 that are actually over 60, but there's 11 attorneys over 50 out of that 18. And there are 4 more that are over 40. I am one of the younger attorneys in Uintah County, and I will be 50 next year. And so in relation to that, I would also note for you that I have some personal knowledge related to the plumbers and the HVAC and other issues. My first husband is a master journeyman HVAC, and he got paid for his education. He worked through the entirety of the time that he was working his trade. And at that time that we were together, he made far more than I did coming into practice in his trade. We do have programs. We have WWAMI. We have incentives for teachers. This is not asking for specific treatment or separate treatment of a profession. There are other professions that the state have recognized need that assistance, and I ask you to consider that for lawyers. And finally, the inquiry related to residents. With due respect, I do not agree that an office is simply enough. What I would hope that this pilot program or any permanent program would be to provide would be to facilitate individuals moving to Evanston, moving to Mountain View, moving to Afton, moving to Kemmer. And after that incentive time that they live there and that we have those attorneys in our communities. So thank you for the opportunity to speak today.
Thank you very much. Others in the room? Anyone else wishing to testify? Oh, question? Representative Provenza.
Thank you, Mr. Chairman, and this might be a question that the bar would answer. I know we've alluded to pro se folks coming into court. I'm wondering if we have a number on that I've missed in terms of, do we know how many individuals are coming through our court system that are pro se? So if anyone has that answer, I'd be greatly appreciated. Thank you.
Ms. Butler.
Mr. Chairman, Representative Provenza, we don't have that data right now. I can tell you anecdotally that we've seen an increase. We're working on, I mentioned earlier that we've just implemented a case management system in all our trial courts statewide. The hope is that with this new case management system, we'll be able to more accurately track the number of self-represented litigants in our courts, but we don't have that data today.
Thank you very much. Others in the room who wish to testify on this bill draft? Ms. Butler.
Mr. Chairman, members of the committee, just very quickly would just say the judicial branch is fully in support of this bill. And the other piece of information I think that I would like to convey to you is the bar mentioned that they would be willing to take on administration, and the Supreme Court or the judicial branch would be supportive of that as well. Thank you.
Very good. Thank you. Anyone else in the room wishing to testify on this bill draft? We have someone online. Mr. Hanson, bring him on. Good morning.
Hello.
State your name, please, and tell us what you want us to know about this bill draft.
My name is Jason Hanson, and as many of you know, I spoke yesterday on a legal matter, and I can attest as a citizen that there is a huge need for more lawyers in Wyoming, period. As someone who's facing these huge legal issues with so many aspects, as you all witnessed yesterday, I've contacted just about every attorney that I can find available in your state to help with my case, and I've been turned away by everyone. They've always stated that they can't afford the time that it would take to look into my case because of the extensive nature of it. I've had to be my own attorney at this point, which is ultimately what brought me to this joint judicial committee speaking, because I'm having to exhaust all my administrative remedies before having to take this to court myself. To not have one lawyer willing to listen to my case is devastating. This is not just happening to me, it's happening to many of your citizens in Wyoming. Many of these lawyers specifically stated that they either don't have the time or are too old for this, and that they cannot put in the effort and work for things like this. Your citizens are being negatively impacted by this, and any legislation that can help promote more lawyers in your state, specifically in the rural areas, has to be good for your citizens, as they're having to be their own attorneys. They're having to do very hard research and try to convince people of things without the legal understanding of a lot of the laws, which, as you can all attest yesterday, is hard for someone like me to actually get my point across to you members without a lawyer backing me up. And ultimately, I think this is something that needs to be thought about, and how it will hurt your citizens. I thank you for your time and being able to speak.
Thank you, Mr. Hanson. Very helpful testimony. Anyone else? Seeing none, let's close public comment. Committee, what's your pleasure on the bill? Moved by Senator or Representative Chester, second by Senator Cooper. Any amendments, discussion on the bill? Representative Jennings.
I feel compelled to just make a closing statement here, I think is what the bar would call it. So I don't want people to think that I don't think we have a problem here. We do have a problem. It's across many sectors. And I'd like to thank all the lawyers that came up. I actually count maybe 1 against 19 lawyers that I count in the room. So I think we're okay. But I want this to be part of what I understood of why I fight this way, is that we're going to take the citizens' money and we're going to subsidize. And so I feel like that somebody ought to be the lobby for the poor citizen. People live in rural areas. They live in Wyoming because they love Wyoming. Not all of them. I understand there's problems that come with that, but people choose that. And sometimes it creates hardships. They have to drive 100 miles for groceries or some other thing, or they have to call to the next town over to get a plumber. And so I don't think, I mean, I realize I'm outnumbered. I realize that this bill probably will move forward, but don't think that I don't believe there's a problem. But I also believe there's a problem when we take the taxpayers' money and we subsidize into an industry. And those other things that we subsidize, just because we do them doesn't make them constitutional. I've heard that before many times. Well, we've done it. The other side has said to me many times, listen, it's constitutional until the Supreme Court says it's not. And so I just think that we ought to step back and look at that. It is a problem. I recognize that it is a problem, but every time we do this, we move further away from free market solutions. And this country was founded upon that entrepreneurship. So anyway, I'd encourage a no vote, even though I'm outnumbered by the Bar Association.
Do we have any amendments? Representative Shustak.
Thanks, Mr. Chairman. I have a series of amendments based on the staff comments. I don't know if you want to just go through one by one.
Yes, let's do them one by one.
Okay, let's take, I'd like to move an amendment on page 2. And at this point, it's more of a conceptual amendment because I hear that the state bar is willing to take on administration of this program, and the Supreme Court is happy to let that happen. I think that makes more sense, frankly, because of the constitutional issue. That solves the problem of whether the Supreme Court can rule on a program that it runs. So I would prefer to have this program run by the State Bar Association. The language that we need to do in Part B on page 2, I don't have it written down yet, because I don't think the State Bar is a private institution. We can't give it permission to do whatever it wants to do. So what I'd like to say, something along the lines of the State Bar is willing to administer, and we are willing to partner with it on these certain conditions. And that's the language that I think we need to draft. So that my conceptual amendment is to transfer this program, the administration of the program, to the Wyoming State Bar, and then that the legislature or the state or whoever is willing to participate in this program along the conditions set forth later in the bill. And that would be my conceptual amendment.
Is there a second? Second by Provenza. Discussion on the amendment. Senator Cooper.
Thank you, Mr. Chairman. Is there any reason that the Supreme Court, as it reads, can't establish the program, no matter who actually administers it? As I read this, it says the Supreme Court may establish the rural attorney program, but it doesn't say they have to administer it.
Further discussion? Representative Oakley.
Thank you, Mr. Chairman. I guess I'm not exactly sure what the amendment is that's on the table. So I think I'm, not to make this more difficult, but I think I'm a no vote as far as how it was worded. It just needs to be changed to the State Bar. That's it. This is a very simple change. So if I heard right, that's like so and so is willing to administer. We don't need all that language. It just needs to be changed to the State Bar. So I guess maybe if we can clarify what the amendment is on that.
Representative Shustak.
Thank you, Mr. Chairman and Representative Oakley. I thought about just changing Supreme Court to State Bar. But then what that does is it says, we, the state, give permission to a private entity to do something, which we don't really do. We don't have to give a private entity or permission to set up the program. What the public piece of this is, we are adding funding under certain conditions. And that's the concept that I don't have the language worked out for right now.
Further discussion? Question being called, all in favor of Representative Check's conceptual amendment, say aye. Those opposed, no. No. Further amendments, Representative Oakley.
I move to change it from the state bar, for the Supreme Court to the state bar.
Motion to change Supreme Court to state bar wherever it occurs in the bill. Is that the amendment? Seconded by Representative Provenza. Discussion. Question. Representative Shustak.
Thank you, Mr. Chairman. I'm back in court now. Thank you, Mr. Chairman. There is one place where state bar and Supreme Court appear in the same sentence, so that we need to, that's maybe just a cleanup thing. There's the agreement that the individuals, yeah, it's on page 9 on line 13 and 14. The attorneys agree to make an agreement with the state bar and the Supreme Court. So we can't just change that. That we just eliminate the Supreme Court, I suppose. Otherwise, I'm in favor of the amendment.
Representative Oakley, your thoughts?
I trust that Mr. Fuller will get it right. I think we understand what the amendment is. I just called for the question.
Okay. Question being called. All those in favor of Representative Oakley's amendment, say aye. Aye. Those opposed, no. No. I think that passes. Division, all those in favor, raise your hand. 1, 2, 3, 4, 5, 6, 7, 8. I count. All those opposed. You don't need to count the motion. We have majority in favor. Amendment passes. Further amendments, Representative Oakley.
Thank you, Mr. Chairman. I think we can crank through these in short order, basically staff comments. So let's go to page 10. I think the First Amendment, that it be written in there that they have to live in the county in which they're practicing.
There a second? Second by Case, Senator Case. Discussion?
Question?
Question being, Representative Grego.
Just clarification, are we talking page 9?
Yes, that one is the bottom of page 9, Representative.
So we're clear, the amendment is to require residency in the county,
Yeah, live in the county.
live in the county. All those in favor, say aye.
Aye.
Aye. Those opposed? That amendment carries. Representative Oakley.
Thank you, Mr. Chairman. The next motion will be that we heard testimony from Mr. Gifford, but not restricting how, who it is that can contribute to. So while it's administered through the county, it's not restricted to that on who could contribute. So that a local contribution or match is required, but it's not restricted to the county as far as paying for that.
You have a page and line number?
Well, I'm looking at the staff comment that's on the top of page 10. Go ahead. I'm getting some help. from Representative Craigo.
Representative Craigo.
Yes, sir. Mr. Chairman, that would be on page 6, line 7 through 11, strike paragraph F. I believe that was the request by Mr. Gifford.
What's the motion?
Mr. Chairman,
I'm not sure that's right. I'm not sure that's correct either.
Mr. Chairman, my understanding would be page 6, line 8, delete municipality, school district, or line 9, delete nonprofit. And so it'd just be with any entity. And then, Mr. Chairman, I don't recall if on line 9, if within the county, if that would be intended to be deleted as well.
I'd speak to that, Mr. Chairman.
Senator Case.
Hopefully it's friendly. I think we could remove within the county. You don't care if if Evanston wants to establish a law firm in Evanston wants to underwrite something in Carbon County so I don't think you should restrict it. The entity that's also contributed to be within the county.
So as I'm hearing, the amendment would be, F would be changed to read, a participating eligible county may enter into agreements to assist the county in meeting the county's obligations.
That'd be it.
Everybody know what we're voting on? Any further discussion? All those in favor say aye.
Aye.
Those opposed, no. Motion carries. Further amendments, Representative Oakley.
Thank you, Mr. Chairman. So I'm going back to the staff comments on 10. So I believe, the motion would be to, I guess, expressly allow license suspension for failure to repay. And I think that's what I heard from testimony. That's the motion.
I'm getting a head shake, yes.
So we're good. Do we have second? Just second discussion on the amendment?
Question.
Everybody clear on what we're voting on here? All those in favor say aye.
Aye.
Those opposed, no.
Yeah.
Amendment carries. Further amendments. Representative Provenza.
Thank you, Mr. Chairman. On page 7, I believe the bar discussed, so page 7, line 5, any attorney licensed to practice law in Wyoming, insert after Wyoming, or is an applicant to the Wyoming State Bar.
Second by co-chairman. Further discussion on this amendment?
Question.
Representative Craigo.
Mr. Chairman, so we might leave it up to LSO to insert the exact language, because I was thinking, or as an applicant to be licensed to practice law in Wyoming. I don't know which is proper, but just might.
I would, Mr. Chairman, I'd consider that friendly amendment, just work with the wording if it needs to be changed.
Dr. Fuller.
Can you operate on that portion?
Yeah, Mr. Chairman, I think it would just be or an applicant for admission to the bar of the state, something of that nature.
Okay, we have an idea. Everybody know. Further discussion? All those in favor say aye.
Aye.
Those opposed, no. Motion carries. Further amendments. Representative Chestick.
Thank you, Mr. Chairman. Staff comment on page 3. I think is a great idea to change licensed attorneys to qualified attorneys and insert the definition of qualified attorneys from the staff comment. I think that helps us in a number of different ways.
Second by Provenza. Discussion? All good with that? All right, all in favor, say aye.
Aye.
Those opposed, no. Amendment carries. Further amendments? Representative Craigo.
Mr. Chairman, page 5, insert, change out subparagraph 2 at the top of the page with the staff comment, taking out the reference to age and instead take it to how many people are will be practicing in the next 5 years.
Seconded by Representative Provenza. Adjusting for the staff comment. All further discussion, question? All those in favor say aye. Those opposed, no. Amendment carries. Further amendments, Representative Craigo.
Last one that I have, Mr. Chairman, is on page 11, adding, and this is going to have to be conceptual, but I think the bar had some suggested language, maybe for Mr. Fuller on the sunset, and clarifying that any lawyer that's enrolled in the program prior to the sunset, that it continues after the sunset if they're enrolled prior to sunset.
Okay. Second by the co-sponsor or co-chairman. Discussion. Mr. Fuller, do you have language? You're good?
I don't have language, Mr. Chairman, but I will work it out. Yep.
Okay, so it's dealing with allowing those members who are in the process, even though we hit the sunset date, those people could complete the process. That's the amendment. All those in favor say aye. Aye. Those opposed, no. Amendment carries. Further amendments? Seeing none. Senator Murphy.
Thank you, Mr. Chairman. I just want to explain, I'm going to be a no vote on this bill. I'm big on free markets and capitalism. I believe that whenever we have government intervention into the markets, that's inappropriate. So, and I understand that what we heard today, it's okay as part of the Constitution. I question that myself, but that's why I'm going to be a no vote, Mr. Chairman. Thank you.
Representative Chester.
Thank you, Mr. Chairman. And I do understand the free market concerns that's what has made this country great, but there is such a thing as market failure. And we have a very clear case here of a market failure. And when the markets fail and people's constitutional rights and personal liberties are adversely impacted by that market failure, I think it's the duty of the state to step in and provide some whatever help it can. And I'm therefore a very strong yes on this bill.
Mr. Chairman.
Representative Harold.
Thank you, Mr. Chairman. So if you look at it, for every 100 jobs in Wyoming, 61 of them will be filled. 49 won't. Or 39 won't. So that's where we're at right now. The reality is I serve on a board that spans across almost all of the rural states for it's called rural advancement. And it's the concept of it is seeing about churches establishment and retention going forward. 75% of all rural churches will close in the next 15 to 20 years because of lack of pastors. Well, I could sit here and make every argument you just made about lawyers, about pastors. We talked about homelessness earlier. You know, and I personally have helped over 10 people come from the streets into situations where they now have a meaningful life, where they're providing for themselves. So I think what we really have to ask ourselves is, do we have a lack of lawyers? Yeah, I think we know that. But I can go through every single group that we have and say we have a lack of them too. And so the question is, where do we stop? Do we keep rural churches open? Should we subsidize that? Maybe we could work with all of these colleges back east and try to bring a whole bunch of pastors into the rural areas to keep churches open. The answer is no, we can't do that. That's not the role of government. And should we be subsidizing healthcare? Probably not. We shouldn't be doing this for doctors. Do we need good doctors? Yes. But at the end of the day, where's the point where if we continue to play this game, where do we stop? Where do we stop? You guys, we can do this. Next year, the year after that, we could grab a new group. And I would agree with you that, you know what, you sit there and say, this is so they can protect their families. This is so they can have access to the legal system. I understand that. But at the end of the day, where do we draw the line? And is it the role of government? And so, you know, I love the heart behind this of, hey, let's fix these problems. But there comes a point where if the government could fix problems, every problem would be fixed in the nation already. Lord knows we had enough meetings like this. But the truth of the matter is we continue to see problems. So obviously I'm a no, because I just, where's the point where we draw the line and say, if this is the role of government, then we open a door. Because in here, it talks about so many things. If we want to do this, then all of a sudden, every church in the state could be funded by the government now. Because it brings value to the community. So all of a sudden, constitutionally, why can't we fund those? And we could argue it. I mean, there's enough lawyers in the room. I'm sure we could argue it. But the question is, where do we draw the line? And if we play this game, we're going to find ourselves down a road that we probably can't turn back from.
Senator Case.
It's not a market failure. Markets are very messy. We've got a master's in economics. We've got a doctorate in economics. Markets are messy little creatures. Markets also fail when monopolies are imposed. The whole bar requirement for licensure and everything, it's a big monopoly. It's not, it has desirable effects of maintaining quality. It has undesirable effects of restricting the numbers. So that's kind of the licensure and all of that. Why do we require so many lawyers to participate in the legal system? The legal system itself is overly lawyer driven. So you require, lawyers need lawyers instead of having it be more open, accessible to lay people. So it is not a market failure. It is, we have created this problem and we've created it in many, many different ways. And if we were allowed other types of legal access, why can't people practice law remotely? Why can't we do that? There's just lots of ways you could break this barrier down. It is not a market failure.
Representative Provenza.
Thank you, Mr. Chairman. I hear the free market and the argument there, but I also want to point out we have a right to a fair trial, and we've created a structure where that's not accessible to everybody. And while we have a public defender's office that does a great job, not everybody can necessarily get a public defender. Maybe they fit into this gap of funding. And we're hearing that we have more people representing themselves. And those are life sentences sometimes when we're talking about what are the impacts on someone's life when they don't get a fair trial. We're not talking about speeding tickets. We're talking about whether someone has access to their children or not. So plumbers have lots of respect for them. They are a necessary entity in our state, in our country. But we're talking about prison and revoking someone's freedom and liberty because they couldn't necessarily have access to justice. So I would urge an aye vote on this bill.
Question being called. Call the roll, please.
Mr. Chairman, this is a roll call vote for 24 LSO 61, Wyoming Rural Attorney Recruitment Program as amended. Senator Case? Senator Cooper? Senator Furphy? Senator Schuler? Representative Chestick? Representative Crago? Representative Haroldson?
No.
Representative Jennings?
No.
Representative Nemec? Representative Oakley?
Aye.
Representative Provenza? Representative Rodriguez Williams?
No.
Co-Chairman Landon? Chairman Washit?
Aye.
Mr. Chairman, we have 8 ayes, 6 noes.
Thank you. So the bill will go forward. And I'll just say on the record, I'm not sure I'm going to support this when we get into the session. But I thought it was important that the bill go forward, that the members of the body have an opportunity to enter into this discussion. I think it's a much more challenging topic than I thought it was going to be at the outset. And I certainly appreciate the comments on both sides. We'll see how we do in the session, but I wanted it to move forward to the session. So, all right, thank you very much on this bill. We'll now move on to where we at on the agenda here. Looks like vulnerable adults. Your vote surprised me, sir. Give a song and dance.
I think we're gonna power on through. Yeah. So committee, your co-chairs thought, we know what hour it is. I think we're gonna try to power on through. Please take a break when you need to. But I hope you would agree that we wanna do that in deference to our good representative who drove all the way across the state to be with us today, and as well as getting us all home at a decent hour. So we will take up now the mental health and vulnerable adult task force. And I think taking these in order, probably, Katie, if that's all right, let's take a look at LSO 21, Emergency Protective Services Effective Period, and maybe walk on through the second one. We might hold the third one. Does that make sense?
Chairman Landon, members of the committee, this first bill is 24 LSO 21 working draft 0.5 Emergency Protective Services Effective Period. And it expands the effective period for an order for emergency protective services, that it would remain in effect from 72 hours to 14 days.
Okay, thank you, Katie. Are there any questions on this first bill? Pretty straightforward. Katie, my thought was that we could go ahead and walk through 23 as well. And I don't know, Mr. Fuller, if that goes to you, or if it's Katie, if it's still you.
Sure. And Mr. Chairman, I think my hesitancy on this is just that I know that the members sitting at the table are far more familiar with these, and they know these bills like the back of their hands. So I'm a little hesitant to summarize some of these, knowing that they know them very well.
Totally get that. I always go to staff. The committees I chair, I go to staff first, because we're the ones that drafted it. The staff helped to draft it. And so I just thought, if you'd like to explain the bill real quickly, we will certainly go to, yeah, and you're doing great.
Okay.
I agree with Representative Larson. So if you don't mind, maybe just a quick overview of 23, and we will certainly go to the panel.
Sure. 24 LSO 23. This is about DFS and law enforcement cross-reporting. And pretty much what it does is it imposes the same requirements for reporting to DFS on law enforcement that DFS currently has to law enforcement, so that they're both reporting them under similar circumstances, where they receive a report that a vulnerable adult is suspected of being or has been abused, neglected, exploited, intimidated, or abandoned, or is committing self-neglect, which is, I believe, currently what DFS reports to law enforcement under those same circumstances where there's suspected abuse or those types of circumstances. And then 24 LSO 192 relates to guardianships and conservatorships. This one is a little more complicated. It requires,
Katie, I think we'll hold on that one for a moment.
Yeah, thank you, Katie. That I thought maybe the two, and then we'll take up the third one here in a little bit. So, Mr. Chairman.
All right, well, let's Which one do you want to start with, Representative Larson?
Mr. Chairman, per Chairman Landon's instruction, I think if we go ahead and do the 021 first, and if I may, Mr. Chairman, I would just thank you for the opportunity to bring these bills again. You'll recall your last meeting, we in essence went over the bills and requested that we have the opportunity to present them to you today. This task force was created by the Management Council and includes legislative and executive and court representatives. And so we don't have the ability due to that to sponsor any bills. And so these that we felt were a good fit for this committee were these three bills. And with that, because these first two really are around our vulnerable adults and our adult protective service, Mr. Chairman, I'd like to ask Director Schmidt, who's a member of the task force, to provide the comment on this first one, and then we'll move to the next one as you.
Very good. Director.
Thank you, Mr. Chairman, members of the committee. My name is Corin Schmidt. I'm the Director of the Wyoming Department of Family Services. And this bill that's been brought to you today to extend the timeline from 72 hours to 14 days is really about being able for us to have an opportunity to do the case management and to identify specifically what services this vulnerable adult may need. And I think for a little bit of context, it's helpful to recognize that the majority of the work that we do with vulnerable adults is really around case management, which means connecting vulnerable adults to local resources. And oftentimes it takes a little bit longer to get those connections made than in 72 hours. If we have somebody who is under emergency services, which means then that there's a high chance that there has been abuse, neglect, self-neglect, one of the first things we try to do is to find a person, a guardian, someone who will be involved with that person's life in order to get them connected to what they need. 72 hours is not a very long time to figure that out. What we have available to us right now is to go back to the court and request an extension. That is the 72 hours. We can go up to 30 days, but 72 hours, again, just doesn't give us a lot of time to get those things into motion. So in other words, it's just a procedural issue that extending it to 14 days will take less court time, less DFS time, less county attorney time in order to achieve what we need to achieve.
Director, what percentage, if you give me a ballpark, of these cases require an extension beyond the 72 hours?
Mr. Chairman, I don't have that with me right now, but I can certainly get that to you.
Would you say it's the majority?
Mr. Chairman, yes, it is the majority.
Senator Schuler?
Thank you, Mr. Chairman. Just, I think this is a good catch, and I think it's a good thing that we're doing, but have you received any pushback from either clients or agency folks or anybody within the state that feels like this is maybe a bit much?
Director?
Mr. Chairman, Senator Schuler, no, when an adult is at this point where they're involved in the court system, there's definitely a need. And so oftentimes it's really about working with the communities and the other service providers to get that need connected. Those would probably be the people that would push back in general. But so much of it comes back down to trying to find somebody, a guardian or somebody to help.
Senator Case?
Thank you very much, Mr. Chairman. Hi, Director Smith. How are you?
Thanks.
Can you help us by explaining maybe anecdotally or what's happening to this person that is, where are they right now when we're talking about 14 days versus 72 hours? Are they in jail? Are they in a hospital? Are they being supervised at home? Are they unsupervised? So, and what will we be able to do for them in 14 days that we can't do in 72 hours?
Director?
I mean, what more can we do for them?
Mr. Chairman, Senator Case, so that vulnerable adult can be in a variety of places. And so I think giving a scenario might be the most helpful. So for example, we may have a vulnerable adult who's living at home, and they're living at home in squalor. They are hoarders. They have all sorts of issues within their home. And Mr. Chairman, Senator Case, let's consider that maybe this person has diabetes and this person is in a wheelchair and this person isn't able to access food. They're not able to access really basic personal hygiene. And they are at a place where their self-neglect is putting them into a situation where maybe they need some assistance. What we will try to do first and foremost is always look for somebody who will help that person, a guardian, a family member, a neighbor, a church member that will help assist. But in that event that that person continues to decline any services, which are voluntary, and then continues to find themselves in a place where they are so ill that they can't possibly take care of themselves, that may be then the place where we work with the county attorney, ask the court if if the court will intervene, the legal system will intervene in order to allow us to perhaps go in and clean the home and bring somebody in to remove a lot of those barriers or to seek medical care. But a lot of this is going to hinge on competency. And people are allowed to make the decisions, especially as adults, we're allowed to make decisions that may be in the contrary to our best interests. The court involvement at that time is going to really determine if that person is vulnerable and therefore needs emergency services. And competency is going to be a part of that question. So if we have somebody who's demented, who isn't able to make good decisions on their own, who's ignoring all medical care, who's put themselves in a situation where they are at a place where they could potentially harm themselves or even it could become fatal, then the court could intervene and say emergency services. And then we'll do our best to either one, in this case, clean the house and remove those barriers, have somebody work with the local senior citizen center to bring in meals if they aren't eating, work with local hospitals, physicians, et cetera, to see if we can get some medical care as well.
So the difference between the 72 hours and the 14 days, and I'm going to have another follow-up after this, is when the court has to act. So it gives more time to the court. What's the benefit of 14 days versus 72 hours? And I will have another follow-up.
Director.
Mr. Chairman, Senator Case, the benefit is that in 72 hours to get all those things in place would be pretty tricky. And at that time, then if the 72 hours expires and the court decides not to continue on, then the department will step out.
And follow-up, and Mr. Chairman, I'm very so the initial period, the court doesn't have to act, do they? Or how does the initial period get triggered?
Director.
Mr. Chairman, Senator Case, it's a court action. So initially we will work with law enforcement and make a decision whether we want to go to the county attorney and ask them to file an emergency services order through the court. Then the court will then make the decision if the emergency services order is necessary. And then that's when the 72 hours will begin.
Thank you.
And then I'm so sorry, Mr. Chairman, if I could just have
one more.
So then it goes back to the court and they extend to 72 hours, which is burdensome. This way it'd be 14 days. Would it always be 14 days? It's up to 14, isn't it? Not to exceed.
Director.
And then I'm going to just answer the last one so that you could pile up. What about substance abuse? What about when you go in there and they're a raging alcoholic or there's other complications? What about that instance?
Director.
Mr. Chairman, Senator Case, it says up to 14 days and the extension says up to 30. So we're not going to exceed. It will be up to, and certainly once we get something into place, we will then step back out. In regard to substance abuse is a little bit of a trickier issue. So this is where we're going to say it depends. So if we have somebody that is inebriated, certainly within 72 hours, those issues are going to address themselves. They would be sober then we can talk about voluntary services. The court may or may not choose to get involved depending on the request by the county attorney through a petition. But in the case of inebriation, we probably aren't going to approach the court and instead try to just find some way to help that person until they sober up, and then we can talk about services. And I think that's the important part, is that through the community mental health and substance abuse system, it's a connection to those resources that are going to be crucial. So what we'll do as an agency is work with our local community mental health and substance abuse center to connect. They are a priority population. Vulnerable adults are a priority population under the statute that will go into effect on July 1st of 2024. So it is part of the behavioral health reform that's been ongoing for the last couple of years, where the community mental health center says, yes, we recognize this is a priority population person. We're going to work with them, try to get them access or get them into treatment, specifically in this case for their substance use disorder.
Representative Jennings.
Thank you, Mr. Chairman. So in pertaining to this, if I'm reading this correctly, it's really not 14 days because you're getting rid of the excluding weekends and holidays. So conceivably, you could turn it into 18 or 19 days because, I mean, that's quite a jump from 72 hours, 3 days to 14 days, the weekends.
It's the other way. That's
Okay, you're,
Yep. So you just eliminate that, so it's 14 days.
yeah,
That
okay.
includes weekends.
Sorry. Never mind. Wish I had a lawyer right now.
Won't have anything at all ever.
We took care of that.
Director, when you and I visited earlier, you made a distinction about the system that we have in place for juveniles, where we have foster care. We can immediately remove a child and move them into a foster care situation that's safe and clean and all that. We don't have that availability. Can you explain that difference for me a little bit when we're talking about vulnerable adults?
Sure. Thank you, Mr. Chairman. So in our child welfare system, which also includes juvenile delinquents and children in need of supervision, they are minors. They are under the age of 18, which allows then the system to have a little bit stronger of an intervention if necessary. So at the time where a determination is made that a child needs to come into protective custody, law enforcement or medical personnel will make that decision. So a physician or a sheriff, an officer will then decide whether the child should come into protective custody. At that point, they're in protective custody. The child comes to the Department of Family Services where we provide care. It's at that point then that, yes, we have ability to place in a foster home. We can place with a relative. But when it comes to adults, we have no legal authority to remove. And I think that's important because we have to balance a fine line between when a person is really self-neglecting or creating their own harm or potentially harm to others, and the system's ability to intervene in such a way. Oftentimes, I think what you'll see with many adults in terms of vulnerability is under Title 25, when the person's a danger to self or others. And again, that's a determination that's made by law enforcement and the court. Under that, though, the person oftentimes is either in a jail or in some sort of mental health situation, a state hospital, or in so many cases in the private psychiatric hospital in the state. For vulnerable adults, if they don't meet a Title 25 criteria, we're working as an agency to find a physical location for that person to be safe. So it could be perhaps a motel if the person's home isn't safe, or if there's somebody in their home that isn't safe. It could be in an emergency room if they need medical care. We're going to start working with Medicaid to see if that person's Medicaid eligible, so that if they need a higher level of care, like skilled nursing, then that process is under play. But all of that takes time, and 72 hours is pretty limiting.
Let's keep the conversation a little low. Okay. Other questions?
Can I ask another?
Senator Case.
Mr. Chairman, you're so chipper about this. In the case of Title 25, and I'm thinking of these of inebriated homeless people that, and I just can't figure out how 72 hours they can possibly be sober, but they in no way have accomplished anything. They haven't been able to reestablish any family ties. I mean, it's just a that is just a Band-Aid, and they'll just be back out in no time. And I know that's Title 25, and this isn't Title 25, or it could be 25. Does the 17 and 14 days apply to both? What's the difference? And I'm sorry for the dumb questions, but these are important in my community.
Director.
Mr. Chairman, Senator Case, after 72 hours, I would wonder then the conversation is about competency. If that person is making the choice to not want to accept services, if they are clearly able to make those decisions, understand the consequences of their decisions, they are not vulnerable. So it's at that point then, and especially with substance use, where it does get a little bit tricky. But at the place where after 72 hours, if the court has already decided that they need emergency services, I mean, that 72 hours has to be, it starts when a court determines emergency services are necessary. Up until that point, that person's working voluntarily with us and with law enforcement. So the 72 hours is a court action, not a case management action, if that helps to make the distinction.
Very good. Representative Larson.
Thank you, Mr. Chairman. And Senator Case, if I could follow up on that just a little bit, because what you're seeing in this effort with the mental health task force is to add on a new layer of what we have established with the behavioral health redesign. And so in the situation that you talk about in this person, so then he gets sobered up and maybe they can make a decision, and they're not a Title 25, but they still need help, and what resources and what we have available. And so that's why the legislature adopted the state policy to say that for our state dollars that are used to provide mental health services, we prioritize these populations, and there's a state level justice involved, which means that they're in the court system, maybe at the state hospital or someplace else, or they're the non-state involved, which may be somebody in the case that you just referred to who hasn't violated any law, but has an addiction problem. They're indigent and they have perhaps some severe mental illness. And so we adopted and defined a couple of years ago that those people that are priorities, for example, are adults with severe mental illness, indigent clients with high needs, and indigent general access, that then we are trying to make sure that they get the ongoing help, just not the temporary help, but the ongoing help through the community mental health providers consistent around the state. So that's how we've approached in helping those. And this vulnerable adult that's been identified after we've got them sobered up, but needs services, fits into this priority population for ongoing treatment.
Okay. Anything else on 21, Bill Draft 21? Seeing it. Your pleasure, you want to move into the next bill draft, or you want us to act on this one? Our choice. Okay. Then anyone else wishing to testify on Bill Draft 21? Anybody else in the room wishing to testify on Bill Draft 21? Anybody online? Okay, I'm going to close public comment on 21. Committee, what's your preference? Moved by Senator Cooper, second by Senator Furphy. Discussion, amendments. Representative Harold.
Thank you, Mr. Chairman. So I definitely think that a 72-hour window probably is very burdensome. I do question if a 14-day window is the answer. So I kind of want to have that conversation about maybe what this looks like. I mean, a work week's 5 days, 120 hours. Is that the answer? 7 days, a full week? I just think at 14 days, if there were, I mean, I'm not saying there would ever be, and we would hope there would never be a situation where someone's like, man, I feel like this is 100% against my will and against what should happen. And then we could have that conversation take place outside of 2 weeks. So I think definitely having that conversation. So I would do this. I will make a motion to move 14 days to 5 days and include and remove that stricken language excluding weekends and holidays. So basically it's 120 hours and then we put the weekends and holidays back in. That way, if it is a Friday afternoon on and we've got Christmas on Monday, we're not giving you guys into that window. So just that would be my motion.
Is there a second? Second by Jennings. Discussion? Co-sponsor or co-chairman?
Mr. Co-chairman, thank you. Honestly, I'm going to have to just study as we go and learn and listen. We've had a task force that has worked pretty diligently on these, so I'll probably resist the amendment, it having been vetted in another committee already. So I think there's probably good reasons why they settled on 14. We can certainly work it as we go. If this moves forward, we can modify if we see fit. But today I think I'm going to leave the bill where it is.
Other discussion? It seems to me that we're talking about up to 14 days. So if we're able to find resources, you found a family friend or somebody to move this person into, it doesn't have to go 14 days. It's up to, we're just allowing for those individual cases that might be particularly complex and difficult to find settings for people. So, okay, question? We need a roll call on 21. Oh, just on the amendment. All in favor of the amendment, say aye. Those opposed, no. No. The amendment has failed. Further amendments.
Question on the bill.
Question on the bill. Roll call on 21.
Senator Case, Senator Cooper, Senator Furphy, Senator Schuler, Representative Chestek, Representative Craigo, Representative Haroldson, Representative Jennings, Representative Nemec, Representative Oakley,
Aye.
Representative Provenza, Representative Rodriguez Williams, Co-Chairman Landon, Chairman Washut.
Aye.
Mr. Chairman, we have 12 ayes, 2 noes.
So working draft 21 will go forward to the session as a Judiciary Committee bill. Next bill on our list, Representative Larson.
So thank you, Mr. Chairman. And this bill is, as our good staff pointed out very appropriately, is just trying to provide consistency in our statutes where we found a little gap in the reporting process. Right now, if DFS responds to a vulnerable adult case, they're required to report to law enforcement, which is a good thing. And that way, if there's a follow-up, they can say, oh, yep, we knew about this. But the opposite wasn't true. So if law enforcement went out and responded to a call on a vulnerable adult, the DFS agency, local agency, wouldn't necessarily know about it, and then it could escalate or something, and they're saying, well, we just didn't know anything about it. So we feel it's appropriate to make that consistency to where we're moving forward with that conversation, Nicole, and I would divert to Director Schmidt for any further comment.
Director.
Thank you, Mr. Chairman. And it really is as simple as Mr. Chairman Larson pointed out. It's about closing the loop. And Again, understanding that in adult protective services, the majority of the work that we are doing as an agency is connecting vulnerable adults and potentially vulnerable adults to community resources, food, in the way of a lot of reliance on our senior citizen centers to provide those support. Law enforcement may be looking at adult protective services a little bit different in terms of walking in, seeing there's no immediate harm, there's no reason to get involved. But what they don't know is that that person hasn't been going to their medical appointments. What they don't know is that person who typically used to go to the senior citizen center for their meals are no longer going for their meals. They're not leaving the house. They're not being isolated. That's not going to be something that maybe law enforcement is going to know. We may know that, or we can provide opportunity to connect them if that is the case. So somebody is calling for some reason. Law enforcement just isn't showing up to someone's house. Somebody has made a report to them and said, we are concerned. And so with that concern, then if that reciprocity and reporting is happening, then we can do a better job of connecting folks with the basic services that need before they get into a situation where they are truly very vulnerable and have significant issues and needs.
Questions? None? I'm assuming we want to hear from law enforcement about their perspective on this reciprocity. So maybe get Mr. Thompson up here to comment. You two can stay. Yeah. Mr. Thompson, identify yourself.
Mr. Chairman, thank you. Alan Thompson, the Executive Director of WASCOP, the Sheriffs and Chiefs organization. We've had conversations with the task force during their meetings throughout the year, and so far have addressed any of the concerns that law enforcement has. So we have no concern with the draft legislation at this time.
Thank you. Thank you. Any questions for Mr. Thompson? Thank you. Anyone else in the room wishing to testify on Bill Draft 23? Anyone online? Okay, with that, Representative Larson, you want to have any final comments before we take up 23? Very good. Close public comment. Committee is moved by Representative Provenza, second by Senator Cooper. Committee, any discussion? Any question being called? Roll call on 23, please.
Senator Case, Senator Cooper, Senator Furphy, Senator Schuler, Representative Chestek, Representative Crago, Representative Haroldson, Representative Jennings, Representative Nemec, Representative Oakley, Representative Provenza, Representative Rodriguez-Williams, Co-Chairman Landon, Chairman Washut.
Aye.
13 ayes, 1 no.
Joint Judiciary will move working draft 23 to the session. Does that conclude your work, Representative, or do we have more to do? You want to go through 192?
Mr. Chairman, if we may, while we have you as an audience, 24 LSO 192 was really a recommendation that come to the mental health task force from some of our judges across the state on guardianships and conservatorships and reporting. We worked through a couple of versions, and I'm going to ask Elisa if she will just help you to understand what we're trying to accomplish in this bill. As we adopted this in our last to bring forward today, we've heard back from additional judges that in reviewing this, they have, they're scratching their head a little bit with a few questions. And we also reached out to the clerks of court to ask how, because they're involved in collecting these and administering the reports. They didn't oppose, but they had questions. So we'd like to help you understand what it is we're trying to do and then table this bill if you don't mind, and ask that you consider this as an interim topic this next year. It's certainly, we have the time to do that, but to lay the foundation today to just maybe help you understand what we're trying to get accomplished.
Very good. Ms. Butler?
Mr. Chairman, members of the committee, so this idea came out originally of the Elder and Vulnerable Adult Task Force, which was in 2017. There was a report to the governor then, and one of the recommendations was to provide a time limitation to guardianship orders, I think was the recommendation from the 2017 report, in conservatorship orders. This bill does not go that far. It only talks about letters, but really the intent behind that recommendation and the bill is twofold. One is guardians and conservators are required to submit reporting on a regular basis. And so that is something that goes to the court. The judge sees it, and generally it just provides a framework for the judge to determine whether or not that ward is being appropriately cared for and decisions are being made in the best interest of the ward. And so it's really an accounting of the guardian and conservator who's taking care of that ward. And so oftentimes what you will see is we have lay guardians and conservators, so folks who are not generally used to filling that role. So it's a parent, it's a sister, it's a brother, it's an aunt and an uncle, and they're not as familiar with the legal proceedings that are attached to being a guardian or conservator. And so there's a lot of times where those reports just are not received. And so the judges spend a fair amount of time, and their judicial assistants, following up, trying to get those reports filed. There is a statute that requires it, but it does take time and effort on behalf of the judges and the JAs to get that done. And so what the bill does, so that's one thing that the bill is geared toward resolving. And the other thing is probably much more important, and that is there's a possibility that guardians and conservators have an old order, right? So an order from 2015 that maybe doesn't have an expiration date, but for some reason that guardianship has been terminated, but they're still using that old order to act on behalf of the ward. I think that's probably doesn't happen very often, but there's always that risk. So the bill really is geared toward addressing those two issues. And so what it does is it requires, obviously pursuant to statute, the guardian or conservator to file an annual report. And upon that filing of the annual report, the clerk of court, the district clerk of court, would issue a letter of guardianship or conservatorship that would last for 1 year. And so the guardian conservator would be able to use that letter for 1 year to prove to a bank or whoever that they are acting on behalf of the ward, and they can make those decisions on behalf of the ward. And then it would require, after a year, you have to file your next report, or guardianship reports are required to be filed every 6 months. But after a year, that would expire. You would get a new letter from the clerk of court. There are some concerns, I think, with the bill. We did try to vet it, but I think there are some things that we definitely missed. So I would agree with Chairman Larson that this is something that probably needs some additional consideration moving forward, but high level, that was the intent of the bill. And so, Mr. Chairman, I'd be happy to answer any questions.
Questions? Senator Case.
With pleasure. Ms. Butler, thank you very much. Does a guardian need a lawyer to file that report? And how would a guardian file that report without a lawyer if they needed to file such a report? Not saying I know anybody that might need to file a report, but if I did, would you help me?
Mr. Chairman, Senator Case, you do not need a lawyer to file a report. The statute lays out what is required to be included in the report and how often it is to be filed. Oftentimes, I think, and we have some judges in the room, so I don't want to speak for them, but I think oftentimes a guardian or conservator, they'll write a letter to the judge that says, this is what I'm doing for the ward. These are the things that I've done. These are the decisions that I've made. And generally the judge will look at that. And I know some respond. I don't know that that's a consistent practice statewide, but they do look at those. And so it's not, I don't think it's overly formal in a lot of circumstances. And that's especially true for lay guardians who are, and conservators who are not, you know, part of guardianship corporation. They are trying to fulfill their duties and still acting on behalf of the ward.
So Representative Larson, I just asked that you help those of us who might be forgetful on this committee that this might be a topic for consideration for the next interim, and don't let it remain on my table to remember.
Good. I will do my best.
Maybe the good director will help us then.
Yeah.
Any other, Mr. Co-Chair?
Just a final comment, Mr. Co-Chairman, Chairman Larson, thanks for your good work on that task force. And you brought good work to us. Appreciate it, Director. Thank you. And Ms. Butler. I agree with the co-chairman. We just need to make sure to get a reminder that we should take this up, you see. So thank you.
Prosecuting attorneys going to provide us with some public comment about an idea for a prosecutor coordinator. Got everybody up. We'll pull up a few more chairs. Ms. Callis, you want to introduce yourself and tell us what we're talking about today?
Yes, thank you, Chairman Washit. As you noted, since I've come up earlier today, my name is Loretta Howison-Callis. I am the Uintah County and Prosecuting Attorney. I'm also the Vice President of the Wyoming County and Prosecuting Attorneys Association. To the left of me is Ann Wasserberger. She is the Niobrara County and Prosecuting Attorney. And to my right is Tucker Ruby, who is the Johnson County and Prosecuting Attorney. He is the president of our association. Next to him is Justice Couts from the Wyoming Supreme Court, and we are honored that he has provided some support for us in relation to this matter. And then, of course, I'm confident many of you are familiar with Danny Mosby, who is the Sweetwater County and Prosecuting Attorney. He is also the state's representative to the National District Attorneys Association. And in relation to matters, I know it's been a long day, and so I am going to try to make this as short as possible. But I appreciate very much, and our association appreciates your time. We're very grateful for this. And I will start by saying we are not going to ask you to do anything today. We are here to present a concept that we would like for you to communicate with each other and with us over the next 3 or 4 months so that this can be an interim topic for the 2024 session. So that hopefully with work of all of you, as well as LSO and our association, that we can have effective legislation to be considered in the 2025 session. Specifically, we are the only, if not one of the only states, it's very hard to assess with the National Association of Prosecuting Coordinators, but we are one of the only states, if not the only state, that does not have a prosecutor coordinator position, which would be very similar to the executive director that you have for WASCOP. Of course, Mr. Thompson's here, or Jeremiah Reedman's position with the Wyoming County Commissioners Association. And specifically then that coordinator would work to facilitate a number of issues, to coordinate all of us. As you all know, there are 23 elected county attorneys as well as 2 district attorneys that address separate matters, and having all of those very strong personalities, this would be a central position. That person would coordinate and facilitate continuing legal education, And that is something that substantially myself and with Tucker's assistance that we have been doing since 2018. And this year, Justice Couts has been very supportive. He has actually assisted us in trainings on 2 separate occasions and has been in communication with the executive director of the Utah Prosecutorial Council, which is Robert Church. We would also have then a representative that could be here with you during legislative session that could testify and provide input in relation to legislation and potentially even assist or lobby for different legislation. We would work through this coordinator to improve the quality of prosecutors and recruitment, both in the law schools and other ways. And I want to just summarize things so that I get a chance for these other individuals to address issues. The main thing that we are going to be asking you to consider is that there are 2 separate types of prosecutor coordinators that are facilitated across the country. One of them generally is housed in the Attorney General's office in those locations. That is the program that in the model that the state of Utah uses. There are other states that utilize a independent counsel, a prosecutor or district attorneys association. And that is Colorado, Idaho, South Dakota would be examples of that. And so we would like some guidance so that there's effective legislation on how you would wish to do that. Specifically, so that you all know, our association would ask for an independent counsel, something very similar to WASCOP or the Wyoming County Commissioners Association. And that is specifically because first and foremost, there are times when our association does not agree with the Attorney General's office, and that we do have some independence in relation to that. But more specifically, there are prohibitions against lobbying to the legislature. And so the reason that you can have such free access to Mr. Thompson as well as Mr. Riemann is because they are independent of any specific government agency. And if we were to choose to go that route, it would be very similar to the Wyoming County Commissioners Association has Wyoming Statute 18.3.522 that facilitates that membership and to create the organization that then guides for Jeremiah Riemann. And a similar legislation would provide for permission for us to do the same. And then there could be potential modification, and certainly we would be asking in the future for modification of Wyoming Statute 9.3.402 to include the Wyoming County Attorneys Association within the Wyoming Retirement Program, because we would want your support in including them in relation to that. We understand that there would likely need to be a cost study or some other kind of effective issue related to this, although we do anticipate asking each county to also have some support of this, very similar to how the County Commissioners Association is funded. You do fund 100% of 2 of our members associations, the district attorneys associations, and the state also, since we are the prosecuting branch, the enforcement of your statutes, there is also substantial support through Budget 160 that we would associate. And so we can certainly address that in the future as well. I am rapid firing because again, it has been a very long day and we really appreciate that. But more than anything, we recognize that due to our workloads and other obligations that you all, I listened to almost every one of your meetings and I have heard the frustration not only from this committee, but from other legislative committees for not having a more input and communication from your prosecutors. We want to do that. And I'm going to definitely allow my esteemed colleagues to communicate, but we would really like to have this be a bill that we can consider during the interim session and have your support.
Very good. Others on the panel wish to comment this morning? Yeah, looks like you think it was covered, Justice?
Thank you, Mr. Chairman and senators and representatives. I want to be sure you understand my role here is not just to support the prosecutors. I support education and quality for all of our judicial system. And during this past year, I became aware of a number of young prosecutors who really had very little experience and very little opportunity for education. They're thrown into the fire quickly. And I also found the same to be true with public defenders. And it's important to me, and I think it's important to all of us, that both of those offices be as high quality as they can be. After all, these people are my lawyers. They're your lawyers. They represent all of us in court, as the public defenders don't. But so I made a few phone calls of what do you guys do? How do you get education? And it turns out that there's a person at the Attorney General's office who tries to annually put on an hour or two of education for them at the Waco meeting. And otherwise they're on their own to do that. And I checked with the public defender, and of course the public defender has their own administrative way of doing things, and they have a very specific setup education program where these prosecuting attorneys do not. So then I started asking around, what do other states have? And I ran into the same thing that you just heard. And I contacted the prosecution instruction outfit in Utah, because it seemed to me like they had a similar circumstance to Wyoming's kind of prosecutors. They have some county attorneys and some DAs, and they were really generous in helping us put together a couple of training programs for prosecutors this year. And I just did that as on behalf of the court, and I hope I didn't step out of line and say, well, I'll do this for prosecutors. I would do it for defense counsel as well. But it's my goal to see if we could find a way to ensure the highest quality training, a systematic training, good training, even like starting with a boot camp and on your way up. And you can see the prosecutors nodding their heads yes. It's a special role that they have, and it's a very hard role that prosecutors have. And I'm hopeful that we can find a way to do that. So either of the two models, the one that Utah uses, or perhaps Idaho or Colorado, both of those are very, very useful, and I think they would help. They would help all these young lawyers. We had a lot of experienced prosecutors come to our training, and I think it was valuable. So thank you.
Representative Oakley.
Thank you, Mr. Chairman. Thank you, Justice, and all of you for being here. And as I ask this question, we're the ones that should probably know the answer to it, and I'm asking you, but to point, this has always really struck me. Do you know how much state funding there is and how much is spent specifically on training for the public defender's office? Because that's something I know already. They've gone to a capital punishment training in Las Vegas. I know they put an in-house, and we don't have anything specifically set up for prosecution. But so back to the question, do you know or anything about the state funding spent on training public defenders and defense attorneys, and would you support the effort for equal funding for prosecution?
Now, Mr. Chairman and Representative Oakley, I don't have those numbers, but I know they're available. So we can get them for you, or somebody can get them for you. And I don't know. And I don't want to be here saying Ms. Lozano has a ton of money for this. You know, I think she's shorthanded and short funded all the way around, and is doing a marvelous job of keeping the boat afloat. But our system, which is a wonderful system where we have prosecutors elected locally, puts all of that cost to the counties, and there really isn't any way. They're enforcing state laws, but there isn't any way for any of the counties that I worked in to send prosecutors to boot camps.
Other questions, comments? All right, Mr. Co-Chairman.
So, Mr. Co-Chairman, I just wanted to thank Justice. Thank you for being here, Your Honor, and all of you for such a great process. I mean, getting out ahead of something, giving us the heads up that this is something that you'd like to have a look at, and I think that's the way this is supposed to work. And I think I look forward to the conversations ahead and to what we can do. I love this state. I've got to say that I picked up on a last name that I bet there might be some relationship to the Wyoming Senate there, Miss Wasserberger. So thanks to your family for that. We miss him, by the way. And then I look at the other end and I see Mr. R. Mosby. I was a basketball referee, and you know what? I got to referee a state championship 4A state championship basketball game, and it was with an Aaron Mosby. So I just love the connections of Wyoming, and thank you for giving me that opportunity.
You're welcome. Just the same thing we asked of Representative Larson is that we'll anticipate that it'll be on your shoulders to remind us as we get close to picking topics for the interim following the budget session, that you'll keep us reminded that this topic is something that needs to be considered for our topics in the interim. It's just less that we forget. Well, very good. Thank you again for all of you for being here. Okay, before we get to committee directives, ask the LSO folks to give us a wrap up. One of the things we discussed early on with regards to the internet crimes against children would be that the co-chairman and I would draft some correspondence to the Attorney General and the Joint Appropriations Committee endorsing some funding for that operation. If any of you have suggestions on language, please feel free to send those to me. I would expect it within the next week. Co-chairman and I will be drafting that correspondence. So anyone on the committee who wants to chime in on the verbiage for that, please let us know. And with that, Katie, Mr. Fuller, you want to bring us home?
Yep, Mr. Chairman. First, real quick, in response to Representative Oakley's question, the Office of Public Defender's budget for the last biennium was $35,000 for capital case training. That was the only reference to training I could find in their budget. 85% of that 35,000 was general funds. The rest was special revenue. Mr. Chairman, with that, I'm happy to run down the committee's actions from this meeting and then reference the bills that the committee sponsored at the last meeting. So at this meeting, the committee sponsored 24 LSO 47 cold case database, 24 LSO 288 promoting obscenity and sex offender registration, 24 LSO 56 the general sex offender registration bill draft, 24 LSO 285 hemp limitations and prohibitions, 24 LSO 284 peace officers record and reporting, what I would call 24 LSO 63 the bill draft to amend 65305 to insert judge into that existing offense, 24 LSO 61 rural attorney program, 24 LSO 21 emergency protective services the protection period, 24 LSO 23 Department of Family Services and law enforcement cross reporting. And then, Mr. Chairman, from the previous meeting, the committee sponsored 4 bill drafts: 24 LSO 48 public records DOC investigations, 24 LSO 54 Controlled Substances Act possession amendments, 24 LSO 44 Uniform Child Abduction Prevention Act, and 24 LSO 46 interference with parent-child contact. And Mr. Chairman, I would assume that LSO would work with the two of you, with the two co-chairmen on the division of bills between the two chambers for introduction.
Yes, exactly. So
thank you,
I think
Mr.
that
Chairman.
totals 13. Is that your count?
That was my count, Mr. Chairman.
Mr. Co-Chairman.
So, Mr. Chairman, committee, and we're nearing the end today, but I wanted to reference all of that work and really appreciate the work that we've done throughout the interim. Look forward to working with you to make those bills even better if we have the opportunity to do that. I think most of those bills had pretty strong support from the committee, and we'll just have to see if there is consideration given to them. But I didn't want to go without thanking every one of you for the work you've done. So it's been a pleasure to work with you.
I would echo that. Very thankful for the effort. Committee came in well prepared read the bills, asked great questions, and I think that makes all the difference when the committee puts forth the work that's required to make bills good. But on top of that, I just want to ask the committee to join me in thanking the LSO staff. We would be so much less if we were trying to draft legislation on napkins sitting around the table up here like the old days. And my goodness, we are so blessed to have a great cadre of people assisting Joint Judiciary. And for all of you, thank you very much.
Thank you. Thank you, Wyoming PBS for.
Wyoming PBS, yeah. You know, PBS is here long before we get here in the morning, and they'll be here along while we're down the highway. So thank you for all your effort with all the technology and for making our meetings available and accessible to the people of Wyoming. Very, very, very important. So, with that, Mr. Co-Chairman.
Nothing from my corner. If there's anything else from the committee, please weigh in with us. We're going to try to communicate to appropriations and to the management council, the work, kind of reflect the work that we did during the interim. So if you have something you want to make sure we don't forget, please reach out to us. Otherwise, we'll be working closely with Brian and the crew to draft something that will give them a heads up. So thank you very much, Mr. Chairman. You're welcome.
And all of you who sat out there in those nice, comfortable chairs throughout the meeting, thank you for being here and participating. With that, we're done. We adjourn.
Everybody, Marcia went and got us tacos and potato ole, so there's food over